Admission which year?
2023. The urgency is that
When do you want it?
before the 16th year, Lord.
All right, any date before 16th. Yes.
May please, your Lordship. I beg to mention item number 8, my Lord. The Learned Counsel ZRA Muttaki is ill, my Lord. So on behalf of him, I pray for adjournment.
Item 8 at the request of Mr.
MAI Hussain on behalf of
MAI
ZRA
Hussain on behalf of the Mr. GRA Muttaki stands adjourned for 1 week.
for the demand.
May I please fill up? I beg to mention for listing of 2 number of documents.
Read petitions
Yes, sir.
for admission.
Yes, sir.
All right, date will be fixed by the court master. Give it to the court master.
On Friday, Lord.
No, he'll give you a date.
May please, Lordship. I beg to mention withdrawal, Lordship.
Withdrawal.
Yes.
All right, tomorrow.
May please, Lordship. I beg to mention for listing for orders, my Lord.
Orders.
Yes, my Lord.
Date kita file. Yes.
May please, Lordship. Lordship, I beg to mention for listing of I, Lordship, for tomorrow, Lordship.
Not tomorrow. Day after.
Lordship, main read petition was listed tomorrow, Lordship. Yes,
Huh?
my Lord. Main read petition was listed tomorrow.
Main list read petition is listed. All right.
May I please, Lordship. Lordship, on admission matter, my Lord. May I pray on Friday?
Huh?
May I pray on Friday, my Lord?
Listing of matter.
My admission.
That is up to the court master. He'll fix a date. Give a date. Next week.
May I please,
Yes.
Lordship. May I please. Lordship, I beg to mention item number 32 of this daily list.
1-3.
32, Your Honor.
32.
If the matter may be adjourned for the day, as my senior Mr. R. Hussain, he is out of station. I've
It
taken
is
the consent
submitted
of the other
that
side.
arguing counsel. Have you taken consent of the other
I've
side?
taken
Yes.
the consent of the other. Okay.
You are for the response. It's submitted that the arguing counsel is out of station. Therefore, matter it is prayed that the matter be adjourned for 1 week,
2 weeks.
2 weeks. Listed after 3 weeks. Yes.
Obliged.
May I please, Lord. Lordship, with the consent of other side, my Lord, I beg to mention item number 41, my Lord. And for the respondent manner, with the consent of the review petitioner, my Lord, and Upadhyay, my Lord.
Yes.
This matter may call after 4 weeks, my Lord.
You are for the petitioner.
No, my Lord, I am the read petitioner, and the review petitioner is the Anupadhyay.
Who is the review petitioner?
Anupadhyay, my Lord.
You have to take his consent.
I have to, in the morning, I have taken consent,
It is submitted by Mr. Mubarak
Lordship.
with the consent of the counsel for the petitioner that the matter be adjourned for 4 weeks. Prayer allowed list after 4 weeks.
May please, your Lordship. Lordship, I beg to mention item number 34 of today's daily list. Lordship will be filing an additional affidavit in this matter. Lordship may kindly grant us 3 weeks' time.
Item 32, 34 be listed after 3 weeks, enabling petitioner counsel to file the additional affidavit.
Much obliged.
May it please, your Lordship. I beg to pray before agenda matter, item number 28, Lordship. I've already taken the consent from the other side to file the rejoinder in respect of the affidavit filed by the respondent.
You are for the petitioner.
Yes, Lordship.
Your name?
D. Burman, Lordship.
D. Borman. Mr. D. Borman, counsel for the petitioner. Praise for is granted 2 weeks time to file rejoinder affidavit.
Lordship, interim order may be extended.
Interim order passed earlier, if any, will continue till the next date fixed.
Highly obliged.
List after 2 weeks, give it a date. Yes.
Your Lordship, I beg to mention item number 30. Your Lordship, my senior is not available right now due to some personal emergency.
Item
number 30.
30.
30.
It is mentioned, been listed by order.
Yes, my Lord.
This matter is shown to be listed by order. It was listed because some mention was made.
From their side only, Lordship.
Huh?
From their side.
Exactly. So you're now praying for an adjournment. Why?
Sir, my senior is not available right now. He's out of station.
Item 30 be adjourned for 3 weeks
Okay.
at the request of the learned counsel for the petition. Yes.
Yeah, because Lordship,
There was an amicus. Mr. Dotto is the amicus. He is appointed the amicus by the court.
My learned friend is appearing for one of the petitioners in one of the case. There will not accept others, sir. Am I He's representing that.
We are appearing for 4431.
I am appearing for respondent number
Rest-
5. Petition number 5.
What is your writ petition number?
4431.
Yes, 4431. Yes.
So, my lord, in this case, limited prayer is this. They
Hmm.
are appointed as casual level. Thereafter, their services were regularized by the government, and after regularization for some months, my petitioner got salaries, etc. But since June 2006, he is not receiving any salary, and he has already retired in the year 2018. In between, nothing is given. Now, what is our case, Lordship, may kindly see the order, regulation order we have annexed here. Kindly see page 23. In pursuance, let me see, 23. In pursuance of government letter number so-and-so, dated so-and-so, and finance department number so-and-so, the following masteral workers are appointed for the purpose of regularization of the services with effect from 22/7/2005 until further order under Silchar division, irrigation Silchar in the scale of so-and-so. Here my name, I am Kanta Prasad Rai. My name appears as serial number 5. So our case is this, my lord, that this order was passed on 6/10/2005. Thereafter, up to May 2006, I have received salary. Thereafter, no salaries, no GPF. In the meanwhile, I went on retirement in the year 2018. But the case was filed in the year 2008. So at that time, I was in service. So that meant that when I went on
You
retirement,
received salary up to which year?
up to May 2006.
2006.
Yes.
This order has not been revoked.
They say that revoked, but we have no knowledge. Now, how they can revoke? Because initially we were appointed long back. So, if they have revoked the order, we have not got any receipt. But I have heard.
Now, what is your prayer now?
My prayer is this unpaid salaries. Since the month
Only
of
salary.
salaries since the
No. Only is your claim for only for area salary,
salary as well as the retirement benefits.
pensionary benefit. Okay. Yes,
That is limited prayer.
Mr. Dhor.
My lord, on the last occasion, there was a direction. I'm appearing in item number 2, my lord, for the PWD. On the last occasion, my lord, there was a direction from this court to seek instruction as to what is the present status of the petitioner's, my lord, service. My lord, they have accepted that minimum pay scale. So, in regard to that, once they have admittedly accepted that regularization part goes. So, my lord, that was my instruction, my lord, that I have received. And my lord, this matter has to be hard, my lord.
By another bench.
No. By your lordship only, my lord. Has to be hard, my lord. It means, my lord, my friend P. Naik was handling this matter. He is yet to, my lord, reach the court, my lord. My lord may take it after some time more, fix a date for final disposal, my lord. That is my prayer.
Yes.
Well, old case, let it be taken at 2 p.m. In the meanwhile, perhaps he will come.
What do you have to say, Mr. Dotto?
There are sets of 6 cases, my lord. And my lord, I have made a brief note, my lord, with regard to these cases. My lord, of course, the prayers are a little different everywhere, my lord. It's not the same prayers that have been made, my lord. Now, my lord, item number, my lord, this WPC number 4431/2008, my lord, where my learned friend, my lord, appears for petition number 5, my lord. Here, my lord, there are 6 petitioners, my lord. Now, the stand is, my lord, that the petitioner number, except the petition number 2, my lord, who received his salaries up to May 2008, others have received their salaries up to May 2006. Now, the stand of the department here is, my lord, that the regularization order which was issued in their favor, my lord, that order, my lord, is invalid because, my lord, they say, my lord, the government, my lord, the list which the government, my lord, approved, my lord. that list did not contain their names. Therefore, my lord, they are saying, my lord, that these regulations are not proper, my lord, and therefore, my lord, they are not entitled to the salary. That's the stand of the government. Respondent number 2 and 3 have filed their affidavit taking similar stand, my lord. And my lord, respondent number 6 in his affidavit says because of non-receipt of retention, my lord, the salaries could not be paid, my lord. Now, my lord, that is where item number, my lord, that is writ petition number 4431. Now, my lord, in writ petition number 1203 of 2013, my lord, he is, my lord, in the my lord, 4431, they are under, my lord, irrigation department. Now, my lord, 41202 2013, my lord, one Baluram Roy, my lord, he is in, my lord, PWD. He was engaged, my lord, as a master worker in 5/4/1992, my lord. And my lord, he is basically seeking.
No, so essentially, what is your submission?
My lord, submission here is, my lord, that my lord, initially, though, my lord, this, my lord, in the first case, my lord, that there is a, my lord, finance department, my lord, communication, my lord, or my lord, a list of regularized employees. That employee list, my lord, there was, my lord, also a rider, my lord, that the corrections, this is a corrections to be made. What, my lord, it appears, my lord, is the executive engineer, my lord, replaced some of the names, my lord, which were in, my lord, either in duplicate, my lord, there, my lord, twice these names were appearing, or some people were not in service, my lord, their names were included. In their place, my lord, he had put these names of 6 persons in the first case. But, my lord, the government thereafter, of course, did not, my lord, respond or regularize that, my lord, or, my lord, did not indicate that this.
You mean to say that these persons were not in service?
They were in service, my lord.
Then
They were in service.
whose names were replaced?
My lord, some people who were not in service or some people whose name appeared twice in the list
So they were replaced by
these 6 persons
Hmm.
of WBC number 4431 by the
Okay.
executive engineer.
Okay.
But the only thing is that the government thereafter did not approve that correction by the executive engineer, as it appears from whatever their record, their papers are there in the file. But then the fact remains that they were in service, and, my lord, there are subsequent, my lord, notifications, my lord, or where, my lord, or in fact,
So
the
which
memorandums.
departments are involved here? PWD is one, agriculture, irrigation,
Inland
then
water transport, my lord.
N,
Inland water transport.
inland water. Transport.
Yes.
All right, you come back at 2 o'clock then. Mr. Nayak is appearing, I'm told.
Thursday, my lord, I'll be out of station, my lord.
He's out of station. What is the difficulty at 2? We'll take it up at 2 p.m.
My lord, I have not been provided with the affidavit filed by the department.
You take a copy. This is hardly a submission to make today at 2 o'clock. All the departmental councils be present. For the matter. Yes.
Matter relates to compensation and appointment law. The husband of the petitioner died on 6/11/2013, Lordship. Connected to Lordship, page 30.
Yes. Dima Hasau. Who's for Dima Hasau? No, but if the standing council is not there, it's an old matter, 2015 matter. Why have you come after so many years?
So the matter was dismissed for default, Lordship, long back in the year 2015. And by my lord order, Lordship, that has been restored. And accordingly, the matter is been.
But here, see, all seems to be Lordship, the government department, Lordship. And I can appear 1, 3, 4, and 5, Lordship. Except
the
to
grievance is
General
against-
Administration Department, Lordship.
Grievance is against the DC,
Yes, Lordship.
number 3, DC. DC has rejected the prayer as the chairman of the DLC.
Or to may come to page 23, Lordship.
Lordship, today I am without the brief, Lordship. Lordship, may kindly take it up after 10 days, Lordship. I shall appraise with instruction, Lordship.
We'll permit you. We'll
Lord.
permit you to obtain in the, yes, 23,
20, page 24, Lordship. The last
24.
paragraph.
What does it say?
Then as per DLC meeting held on 18 to Lordship got it. Last paragraph.
Last paragraph.
Yes, Lord.
Read.
Last two lines.
Yes.
As per DLC meeting held on 18 to 2014, also recommending the case of Srimati Purnima Telegu, wife of Dilip Telegu, junior assistant are found invalid against the street of so and so, Lordship.
You are reading from
Reading from last paragraph, page 24, Lord. And page 25 is the vacancy chart, Lord. Relevant page, it is Lordship, page 42, 27, Lord. 27, last. My post was recommended for grade 3, Lordship, initially.
yes. Now read 27.
Yes, Lord. That is the vacancy chart, Lordship.
No, you are reading from some
Yes, Lord.
document. Where is
Page 24.
25? 25 is the
25,
minutes.
Lordship.
25 is the minutes.
Yes, Lord.
Yes. Which paragraph?
Paragraph second, third paragraph, Lordship.
Yes.
The guidelines contain so wherein it is stated the department can appoint one person on operational guard against 5% quota up to 20 vacancies in a year. Hence, the cases in respect of so and so, and serial number 5, Srimati Purnima Telegu, that is the petitioner, Lordship, were reviewed in the DLC meeting, adhering to the government OM so and so. Serial number could not be recommended on the ground of non-fulfillment of criteria of the OM based on vacancy position of this establishment as per vacancy shown below, and the DLC decided to cancel above 5 cases which were earlier recommended by DLC. The vacancy position is, Lordship, that is page 27, Lordship. Serial number 8, Lordship, year 2014. The remaining vacancy in the year 2030, grade 3, that is 6 numbers, Lordship. Current year nil, Lordship. Remaining vacancy in the year 2030, grade 4, 5 numbers, Lordship. Current year nil, Lordship.
Yes.
And my pair is that the vacancy in respect of the establishment of Deputy Commissioner Dima Hospital, Lordship, if the vacancy position is nil, it can be accommodated in some other establishment.
Depending on what the OM says.
And there is a judgment.
Where is that OM? Where is that OM? OM of which year?
OM is not there with me, Lord.
2009.
Yes, OM will be applicable of that time only, Lordship. As per
You
Honorable
see the
Supreme Court
OM of
judgment, Lordship.
2009? What? Where is the OM of 2009?
I do not have the copy.
You have a copy?
Do not have the copy. I'm relying on the judgment of the Honorable Court.
No, first show us the OM.
I do not have.
Yes, we have it. Yes, what judgment?
ঠিক আছে। Okay.
Paragraph 16 and 17. In view of the above, it is directed that henceforth all the DLCs and SLCs in the state Assam shall given a consideration not department or office wise, but taking the sum total of the total number of vacancies in all the departments, and thereafter arrive at an interesting financial comparison of all the applicants in respect of the department, and thereafter make the recommendation in the order of the applicants who are financially worse off, subject of course to their suitability, their qualification for the given post. This order shall not be construed to be an order requiring the DLCs and SLCs to reopen the earlier cases, which were already considered and dealt with the department wise, as was done earlier. In the instances, the DLC may consider the case of the petitioner again for any other post where vacancy may be available in as much as although the application of the petitioner may have been for the post of LDA. But under the law of compulsion and appointment, such indication is merely a desire, is not to be construed that the applicant is to be considered only for the post for which the application was made.
But this was passed to when?
17,
17. And the order you are challenging?
2015.
Then is there anything in the judgment where it says that it has to be considered? Achyut Ranjan. You have not brought a copy of the judgment.
I do not have the paragraph 8 is there, Lord. The judgment is there. Considering the aforesaid aspect as to why compensation of appointments are being
This is
also-
with regard to financial
Yes,
status.
Yes.
Your claim is not that. Your claim is that consider the case regarding any other vacancy. Any other consider the claim of the petitioner with regard to any other vacancy.
Otherwise, financial constraints are there, Lord.
But that is not the ground on which it is rejected.
Yes, sir.
Then in the judgment it is not there.
Yes. Correct.
Then
And Lordship, if at all has to be considered, Lordship, the principle has been set by NC Santosh case, Lordship, of 2007. It has been
correct.
set by-
We are asking you
Yes.
what is your stand in respect
Yes,
of
Lordship.
the vacancies, because you have to. Where is the earlier recommendation?
Earlier,
Where is the earlier recommendation?
Lordship, page 23. Page 23, that is a corrigendum, Lordship. First paragraph, Lordship. Another case, Srimati Purnima Telugu, wife of Dilip Telugu, for the post of junior assistant as per DLC meeting held on 18 to 2014 under the amalgamated establishment of Deputy Commissioner Dimahasa of Haflong. and communicated to the government by so and so, so and so.
So in terms of this order, there's a notification which was in force 2009. 2/3/2009 notification was there. Where is that DLC meeting minutes? 18/2/2004. Do you have a copy with you?
I do not have a,
Do you have a copy?
I do not.
Madam, you have to get this.
Lordship, I shall get instruction.
Page number 23.
Lordship, I have.
18/2/2014, whereby their names were originally recommended.
Sure.
You get a copy. Heard learned counsels for the parties. This writ petition is filed with the petitioner. Agree by the cancellation of her recommendation by the DLC for being considered for appointment on compassionate scheme. Stop. The DLC had earlier by its minutes dated 18/2/2014 had recommended the names of the petitioner. Stop. Subsequently, by the DLC, by the Deputy Commissioner, by the DLC was recalled on 6th August 2014. So thereafter, a corrigendum was issued dated 16 June 2014, whereby the case of the petitioner, along with other similarly situated persons whose names were recommended earlier, stood cancelled. Stop. Agree. The present writ petition for the sender is before the court. Where from the pleadings, it is seen that there is a reference of the DLC minutes, DLC meeting held on 18/2/2014, by which the names of the petitioner along with other persons were recommended. So, however, the same minutes is not available in the pleading. Copy of the said minutes is not available in the pleading. Stop. To decide the matter, to decide on the prayers made by the writ petitioner, copy of the said minute would be necessary. MSM Bhattacharjee, learned common advocate, appears for the respondent. A respondent state she is requested by the court to obtain a copy of this said minutes dated so and so 18/2/2014 for perusal of this court. The copy of the minute be placed before the court on the next date text. List after 3 weeks. We'll give you 3 weeks time. Madam, we are giving you 3 weeks time.
Lordship. I
List
reply.
after 3 weeks. The counsel for the petitioner will furnish a sufficient copy of the writ petition to the respondent counsel within 3 working days.
Obliged.
Give a date. Start.
Quickly apply.
First,
11, 12.
11 December.
Obliged.
Here the challenge of the writ petitioner is to the compulsory retirement which was imposed upon him by the Assam Rifles, my lord, on the ground that he was medically unfit. My lord, this honorable court
Is
has
it covered?
my lord, that judgment would cover. And even now they
notice. I have to obtain instruction whether it is actually covered or not.
Why issue notice? You get your instruction. If it is covered, we'll close it.
if his retirement, if they admit that the retirement is was on medical grounds and not due to the service.
Where is that order?
My lord, that order I was never supplied with. So she would find that annexure 1, page 24.
Page 4.
Page 24, my lord, annexure 1 is the only piece of document I was given. FS retiring pension, refer your order number so and so, service review 6 so and so. Havaldar ORL Dilip Rudra Paul of your headquarter will be proceeding on retiring pension with effect from so and so. Now, therefore, it is only on my pension order that they have stated somewhere saying that it is on medical grounds. But they have to say, my lord, he has to have instructions whether it was on my service review or it was on the medical grounds that I would need to retire. Because Lordship would find at later stages also, Lordship finds at page 30A, the new policy that they have now started. And at page 31, my lord, annexure 5, they have cancelled retirement orders of other persons following the judgments of the Honorable Court. Page 31, Lordship will find.
No, but from here, does it appear that you were on medical ground?
But the only document that was given to me is
24.
Page 24 did not say so. But, that is why they'll have to get the instructions.
Let
only
them get
on
the
the
instructions.
pension payment order.
You get your instructions.
Lordship,
On-
actually it's a order directing him to retiring pension in the year 2017.
Could
So long back, Lordship, that is why I may have to file my affidavit also. Lordship.
You tell us whether it is covered or not. That's all. If it is covered, if it is a medical ground, isn't it? Low medical ground.
If Lordship
Low, what do you call it? Low medical
Low
medical category.
category.
If Lordship would only have serial number 4. This is pension order, my lord, serial number 4, if Lordship finds.
Yes. On medical
Retiring
ground.
pension on medical ground. When the
Why
order
we
was,
not? Why we not enclose this?
my lord, that is the pension payment order. They have to show from records that it is from medical ground.
Anyway, heard learned counsel for the petitioner. You want us to issue notice, or you can get instruction.
Lordship, without notice may be difficult. That is why I am praying for notice. Lordship.
Heard learned counsel for the petition. This writ petition is filed by the petitioner, challenging the impugned order. Dated 8 November 2021, whereby the earlier order directing the petitioner to proceed.
Well, this is not. This is where they have taken a policy decision to cancel all retirement orders.
Page number.
Page number 31, my lord. That was the policy decision taken to cancel all retirement orders based on medical ground.
By which the respondent authorities took a decision to cancel all retirement orders on which were earlier put on medical ground. So pursuant thereto, a communication was issued to the petitioner. You have not received any communication after that?
No, ma'am.
You submitted that pursuant to this policy decision, no further communication has been issued. But what about your pension?
Pension they are paying me.
You're receiving it?
Yes, yes. The Honorable Meghalaya High Court, my lord, in a similar set of cases have held that the person should be taken to be in service.
No, is there any order for seeking recovery of the amount paid to you? Nothing.
No, no. If they continue me in service, then the amount of salary that I was required to be paid minus the retiring pension will be paid to me and I'll be allowed to continue in service, or
No,
I
is
may
there
go for
any
voluntary.
order directing you to get enlisted back to service?
My lord, that is what we are praying for.
Uh,
If we are enlisted back in service, it would be my choice for this policy decision either to go on a voluntary retirement from the date I choose, or they can retire me on medical grounds after taking me through a medical board.
and
What
this court has already
set aside the orders of voluntary retirement.
not the policy decision.
No, this policy decision is what we want them to implement on us.
Okay.
This 2021 is what we want them to implement on us by cancelling our retirement, allowing us to go on voluntary retirement, or what they did was actually on 30 years of service, anybody who was not medical category shape 1 was directed to be retired. That is what we are against. And that has been upheld by this honorable court, saying that one cannot be retired in that manner. In fact, the
And
Meghalaya High
that
Court
matter traveled to Supreme Court and
yes,
this has been upheld.
2 sets of matter traveled to Supreme Court, came back. 1 set of matter recently decided by the Meghalaya High Court also. The judgment I have an.
Stop. If that be so, the petitioner is required to be enlisted back in service. Stop. This issue has been decided by a coordinate bench of this court in WPC 1421 of 2017 and other connected petitions. By judgment and order 12/2/2021, whereby this court had held that members of these services cannot be by which order the termination orders were interfered and set aside. Stop this. An appeal filed against the said judgment and order has also been dismissed. Stop. The SLP preferred by the union has also been dismissed. Stop. It is submitted by the learned counsel for the petitioner that the issues raised in the writ petition is squarely covered by the said judgment and order dated so and so, passed in WPC so and so, along with other writ. He therefore submits that the prayers made in the writ petition be allowed. Stop. Para MS S. Sharma submits that she does not have instruction and prays for further time, prays for time to obtain the required instruction. Accordingly, let notice be issued returnable 4 weeks. Meanwhile, the respondents will obtain the required instructions as to the grounds on which the petitioner, how many petitioner? Only one. Has been directed to proceed on retirement. Stop. Matter be listed. Is there any respondents, private respondents?
No, ma'am.
Steps on the, since the learned common counsel has appeared, notices are waived, however, extra copies be filed to the learned counsel within 3 working days from today. List after 4 weeks.
Obliged.
You can take back that document.
Petitioner has been compulsory retired from the post of Deputy Commandant of the India Tibetan Border Field Force by without any holding any inquiry by wrongly applying the provision under Rule 9 of the Discipline Appeal Rule of the Department. And because that the order, my lord, he has submitted.
So we'll issue notice.
Yes.
Heard learned counsel for the parties. The petitioner before the court is aggrieved by the impugned order. What is the order dated?
6/8/2021
6/8/2021,
and
as
appellate
well as
authority
the appellate order dated
order dated
28/6.
11/7/2020.
Huh?
Appellate authority's order dated 11/7/2020.
11/7 or 28/6.
My lord, that is the penalty order.
As well as the appellate order dated 11/7/2023, whereby the petitioner was sent on compulsory retirement.
Yes.
And his appeal against the said order was dismissed. It is submitted that he was sent on compulsory retirement without following the procedure and without holding any inquiry. Accordingly, let notice be issued returnable 4 weeks. MS RDB appeared for the respondent since the counsel appeared. Notices are waived. However, extra copies be furnished within 3 working days. You have some interim prayer.
No, they already retired, Lord, they compulsorily retired.
You're retired.
Compulsory.
Okay.
Is there any recovery order? No.
No.
List after 4 weeks.
Apply.
Okay.
Please, my lord. My lord, here is a third petition, my lord. The petitioner was appointed in service as per the Executive Court of the order dated 12/3/92, and he has continued in service and also got promotion. Thereafter, he was retired on 31/3/2021. Now the recovery that they have treated the aforesaid service of the petitioner as irregular service, my lord. And there is a order to recover the, your lordship may look into the annexure 70 decision of the government, page 75. Page 75.
Yes.
Reference to the letter on the subject above, I am that to say that it reveals from the report that Sri Bulbul Niyok, senior assistant office of the so-and-so was illegally appointed, confirmed in service. Therefore, he may be dismissed from service. This order was passed after his retirement. Whatever may be, my lord, your lordship will examine. Then, my lord, subsequent order is passed annexure 18 to recover whatever he has served in the since 12/3/92. That is annexure page 75. Reference to the above, I would like to inform you that Registrar has requested the undersigned to start the process towards recovery to the amount paid to you during your working period as junior assistant.
You have not challenged the termination order, dismissal
There
order.
is no termination order, no dismissal order. No dismissal. Now they are adopting this one, man. So notice may be issued. This your lordship will be examined, Mati. Yes, ma'am.
Heard learned counsel for the parties. This petitioner before the court is aggrieved by the order
No.
dated 28 June 2021, whereby decision was taken by the registrar cooperative, the deputy secretary government of Assam cooperation department, that since the petitioner was illegally appointed and confirmed in service, he may be dismissed from service. Stop. They submitted that pursuant to the decision taken, no steps were taken to dismiss the petitioner from service, and subsequently he came to be superannuated. He retired from service.
Yes, on 31/3/2021.
On 31/3/2021.
Yes, madam.
No, he retired before this order was passed.
Yes, before this order. This order was after nearly 2 years.
He submitted that petitioner retired from service on 31/3/2021, which is prior to the order dated 28 June 2021. So thereafter, by order dated 13 June 2023, the respondents have taken steps, have initiated process for recovery of the amount paid to the petitioner during his period of service. Being aggrieved, the present writ petition has been filed. Mr. G. Bordolo appears for the Corporation Department, who submits that instructions are not available. Accordingly, notice be issued returnable for week. Since the Standing Council for Corporation Department has appeared, notices are waived. Extra copies be furnished within 3 working days from today. Matter be listed after 4 weeks. Meanwhile, order dated 13 June 2023 shall remain state till the next returnable date. It's not 11. List on 11th.
Two connected writ petition may also be pending. One is
submitted that there are 2 connected writ petitions. 2 connected means what? Filed by the same petitioner.
same petition, because
Challenging what?
relating to first gradation list. Then
How is it relevant here? How is it connected? It may be the same petitioner.
same hearing will cover.
No,
all
same
this.
hearing. No.
Okay, madam. Okay. Same hearing will cover, madam. Okay.
How same hearing? The issues are different.
No, issues are different.
It may be the same counsel, it may be the same petitioner, it
but
may be the
arising-
same judge, but the issues are different.
The present issue is different, but arising out of
Then
same
why do you
cause of
say
action.
connected matters?
Arising out of same cause of action.
How? How gradation list is connected
No,
here?
gradation list I have been made junior.
How is this?
First of all, thereafter
You're
this-
challenging a question of
Okay,
removal from
okay.
service.
And second one is for retirement benefit. Okay, madam.
Let us first decide this issue.
Okay, madam.
List
Okay.
again on
Obliged.
11.
Obliged.
Is it covered?
Yes, madam. I have page 57, madam.
Yes, Mr. Pathak,
Yes, let me go with it. It is
covered.
covered as in it's an interim order. Notice may go in
57, page 50.
No, there are other matters.
Yes, sir. Pending matter. Because
pending matter.
they have taken, given, opportunity to take instruction ballot.
Okay, these writ petitions are pending.
Yes.
What is the status in those writ petitions?
They have to file affidavit, madam.
Third learned counsel for the parties, this writ petition has been filed by the petitioners who claim to be working as outsourced meter readers, bill clerks under Dhing Electrical Subdivision APTCL since the year 2012, 2017, 2019. So they're working as contractual employees and paid a meager amount. So you're praying for regularization.
No, to include our name in the consideration list, my lord. Our names have not yet been considered
Considered for
the contractual worker, so that we can get other benefits, my lord.
it is submitted that under which list?
Beg your pardon?
You want your
It
names
is
to
under
be,
Nagaon division, my lord.
you want your names to be
My
included
name,
under
my lord,
which list?
Baharul Islam and 4 others.
It is submitted that similar benefits are being, that certain benefits are being offered to similarly situated petitioner, similarly situated person, which have been denied to the petitioners. Stop. Accordingly, let notice be issued. Returnable for Mr. A.P. Pathak appears for the respondent. Since standing counsel appears, notices are waived, however, extra copy will be furnished within 3 working days from the date. List along with WPC 5649 2023. Extra copies within 3 working days.
Today end.
Yes.
But this matter pertains to
Yes.
appointment on competitive ground. That his name was recommended by the SLC. If I may take your lordship to page 16, Annexure B. Father died in the year
PWD did not take any decision.
My lord, somehow we could not submit our qualification certificate, but later on we submitted all our documents. But till today, they are not taking any initiative to pursue the matter.
Who is for the PWD?
Rahul Dhor is there. R Dhor is
R. Thor. Our learned counsel for the parties, this petition is filed with the petitioner. Aggrieved that notwithstanding the decision, notwithstanding the recommendation made by the SLC for appointment of the petitioner on compassionate ground under the office of the executive engineer PWRD, Nagaon, no action has been taken by the executive engineer PWRD Silchar. Stop. Mr. Goswami appears for the respondents.
2 and 3, Lord.
Huh?
I am on behalf of respondent 2 and 3, Lord.
2 and 3.
Yes.
Mr. R. Dhor, learned standing counsel, appears for respondents 1, 4, 5, and 6. Mr. Dhor will obtain instructions on the next date fixed as to why the recommendations of the SLC has not been acted upon by the executive engineer appointing the petition. Matter will be listed again after 2 weeks. Although notice is not issued, extra copies be furnished within 2 days from today by the learned counsel for the petition. Copy of this order be furnished to Mr. R. Dhor for obtaining the instructions as directed. List after 2 weeks. Give it.
Item 14, my lord, lordship has already heard item 9. This is the identical case, my lord. These persons were retired, my lord, on medical grounds.
So we had fixed some date.
My lord.
14, item 9, 4 weeks. Okay, we are issuing notice that 4 weeks.
My lord.
Obtain instructions. You check up item number 9. Same order.
Okay.
Huh? Names of the councils are Mr. Pathak and Mr. R. Devi. Low medical category.
No medical. So some cases have been already considered. Some other petitions are also pending. The question now is that, my lord, whether the earlier judgment would cover us or not, or whether this policy that has been now withdrawn would have a effect in REM to be applicable to everybody. That would be the.
You want to get back into service?
My lord.
You want to
Mo-
get back into
My lord.
service?
Most of the colleagues have been taken back, my lord. Those who were before the court at that point of time. But then those who are not, my lord, whether they will be covered under this change of policy. That is the
All right.
clear.
Hi, please, your lordship, may kindly pass over the matter for
Huh?
pass over the matter for a week.
Pass over.
Yes, in case
Why?
counsel is out of.
What is the matter? Compassionate.
Compassionate appointment, Lordship, after 18 years, Lordship.
All right, at 2 p.m. 2 p. You want to pass it over today?
Yes, lordship,
Oh.
for a week.
Okay, it's submitted by the learned counsel for the matter stands adjourned for 1 week. All right.
right,
May I please, Your Lordship, this writ petition is pertaining to non-release of GPF of the petitioner, my lord. The petitioner was appointed as cook in Assam Police in the year 1993, but he was dismissed from service by order dated 8 August 2008 because of unauthorized leave. He was absent without any authorized leave.
No, what news do you want now?
My lord, GPF amount, he's paying for GPF amount to be released.
GPF amount.
Yes, my lord.
Service benefit. Heard Learned Counsel for the parties. Petitioner is before the court praying for release of service benefits including GPF amount. Petitioner was employed under the Assam Police as a cook. Stop. He had suffered from severe mental health issues, because of which he could not perform his duties regularly and was on medical treatment. Stop. Because of long leave, which was not authorized, the competent authority initiated a proceeding against the petitioner, thereby dismissing the petitioner from service for unauthorized absence for a prolonged period. Stop. Subsequently, the petitioner came to be aware that he was dismissed from service. However, his service benefits along with DPF amount has not yet been released in spite of representations made by the petitioner. That notice be issued, returnable 3 weeks. Mr. Goswami appears for all respondents. Notices are waived. As the Government Council appears, notices are waived. However, extra copies be furnished within 1 week from today. List up to 4 weeks.
Oh, like my
Please, Your Lordship.
Yes.
The petitioner's father was a regular permanent laborer under the PWD Roads Department, who died in harness on 16/10/2014, Your Lordship. And after the death of the deceased, the petitioner, having no more earning source, applied for his appointment on compassionate ground, Your Lordship, before the respondent authority. But having got no response from the respondent authorities, he filed a writ petition before this honorable court by WPC 1303/2017, and this honorable court, after perusal of the facts and circumstances of the cases, was pleased to dispose of the matter with the direction to the respondent authorities to consider the matter of the petitioner. However, even after the submission of the such judgment and order before the respondent authorities,
Then you should file a contempt. Why you file a writ petition?
they have filed another writ petition.
Who filed?
The petitioner filed another writ petition, Your Lordship.
Where is the order?
By the time the petitioner came to know about the DLC meeting minutes, Your Lordship, from personal sources, that his appointment has been recommended in the DLC meeting. However, in the SLC meeting, it was rejected on the ground that he was underqualified, and it was applied after 4 years after the death of his father. But on the other hand, the petitioner applied for his appointment immediately within the time limit of within the 6 months time limit of
Okay, get instructions, Mr. Dhor.
My lord, if we go by page number 32 of the writ petition, my lord, my lord, this case was, my lord, considered, my lord, by the SLC, page number 33, The second table, my lord, till number 5. Second burglary, my lord. Here, my lord, it says that underqualified and applied after 4 years from the date of death.
No, she says that
But
she
it has
applied
been,
immediately.
it has been recorded wrongly in the DLC
My
meeting
lord,
itself, your
so,
lordship.
my lord, this is under challenge.
So you get your instruction.
No, that notice so much.
All right. Heard learned counsel for the petitioner. Petitioner is aggrieved by the rejection of the claim of the petitioner, seeking compassionate appointment. Stop. The SLC by its minutes, by its meeting held on 16/8/2022 rejected the claim of the petitioner on the ground that he was underqualified and he had applied after 4 years from the death, 4 years after the death of his father. Stop. Learned counsel for the petitioner submits that this ground for rejection is incorrect, as the petitioner applied immediately after the death of his father.
My lord, let them make SLC a party in this case, my lord. Unless SLC is made a party,
It is submitted that the ground for rejection of by the SLC is on incorrect facts. Therefore, present writ petition has been filed. Mr. Ardhor appears for.
I appearing for 1, 4 and 5.
1, 4 and 5.
Fine.
MS M. Bhattacharjee for 6. And anyone for finance? R. Nayak for finance. Stop. Since the challenge is made to the decision of the SLC on the request made by the learned counsel for the petitioner, the SLC is directed to be arrayed as a party respondent number 7 in the writ petition. Stop. Petitioner will file amended cause title. You will file an amended cause title showing respondent number 7 as the SLC, represented by Chief Secretary within 1 week before the registry within 1 week from today. Since learned government advocates have appeared, notices are waived. However, extra copies will be served within 1 week from today. Placed after 4 weeks. Yes.
But the post of Anganwadi worker, non-consideration of the representation submitted by the petitioner by the responding authority. At page 17, your lordship, on representation of submitted matter. The petitioner immediately after coming to know regarding the vacancy, the post of Anganwadi worker at Madrasar Talakura Anganwadi Center, nearby to his residence, your lordship, he approached the respondent authority by this application, your lordship. The prayer for appointment or issuance of advertisement for fresh recruitment. And accordingly, after getting this application method, the respondent authority assured that within a short time, they also had made advertisement.
What is your prayer now?
My lord, thereafter, the respondent authority, without considering the application, your lordship, they have made an advertisement. That is at page 18, your lordship. Next page. Here, by this advertisement, your lordship, the petitioner cannot be made a candidate.
Why?
Because here they are going to fill up the post of Anganwadi worker by way of promotion, your lordship, from the Anganwadi helper, your lordship, who are in continuous service.
And your petitioner is?
not a helper, my lord. He's a fresh candidate. He cannot
Not
apply.
employed.
Not a,
She's not employed.
my. So he cannot
Yes.
apply, your lord.
What is the source of recruitment? Is it through, is it helpers?
Two ways, Lordship. One
Ah.
by promotion and another by direct recruitment, Lordship. In this advertisement, Lordship, through this advertisement, this has been that candidates who are presently the helpers with required qualification, they will be promoted, Lordship. This is absolutely only to name two centers, Lordship, where
Yes,
the
sir.
filling up vacant posts under Lordship, who are helpers, Lordship, in continuous service, in service, Lordship.
On what basis? Is there a set of
Yes,
regulations?
Lordship, there are advertised. There are Lordship.
Third Learned Council for the parties, the petitioner is aggrieved by the fact that the CTPO, Horipur, has issued an advertisement for filling up the post of Anganwadi workers under the Goripur Child Development Project in the Anganwadi centers mentioned in the advertisement, namely number 35, Matrichar. What is the full name? Matrichar.
Majetta Sarata.
West in the under the revenue village of Choka Chora, page number
Solakura.
18, as well as the Anganwadi Center number 116, Majer Chor, Cholakura, under the revenue village, Majer Chor, Cholakura. Stop. The grievance of the petitioner is that the advertisement seeks appointment from the Anganwadi helpers who are in continuous service. This, according to the petitioner, is contrary to the procedures prescribed, as direct recruitment should be the source for recruitment for Anganwadi helpers. Stop. I agree with the petitioner is before this court. Let notice be issued, returnable. You obtain instructions. Why notice is issued?
Yes, no notice, Lordship. Notice is not required.
MS M. Bhattacharya, Learned Council appears for the petitioner, for the respondents, for all the respondents. For respondents 1 to 5.
Yes, Lordship.
Why have you challenged, why have you added respondent 6?
Lord, the petitioner have come to know, my lord, that the respondent authority is going to appoint respondent 6. My lord.
Oh,
And they have
Lordship,
not,
it is the prerogative of the respondents, Lordship. They cannot direct any XYZ, Lordship.
they
Yes, no
have,
locus himself, Lordship.
they have not handed the advertisement, copy of advertisement.
all right, all right. We'll obtain
Technically
required
made it.
instructions in the matter as to the manner prescribed for recruitment to the post of helpers in Anganwadi workers. In Anganwadi centers. Stop. The Learned Government Council will apprise the court as to whether for appointment of helpers in Anganwadi, for appointment of Anganwadi workers, whether direct recruitment is to be initiated or persons in service are required to be appointed, enlisted for service, required to be selected for appointment. These instructions will be placed before the court within 3 weeks.
Yes, Lordship.
3 weeks from today. Depending on the instructions that come, court will consider whether further orders are required to be issued in the matter. List after 3 weeks.
Right.
The petitioner will furnish extra copies of the writ petition on the Learned Government Advocate within 3 weeks, 3 days from today, 3 working days.
Obliged, your lord.
But there was a recruitment rally of appointment of constable. This particular petitioner, my lord, he was selected. As far as the tests are concerned, he had qualified. Case 39, my lord, he was called for medical. But to put Akhilesh Kumar Chauhan is the name, son of Dinesh Chauhan. But then during document verification, Lord would see page annexer 6, page 41. A domicile certificate is required to be produced, page 41. But you could see that his father's name, my lord, there was some overwriting in that domicile certificate, page 41. Annexer 6. Dinesh Chauhan, that Chauhan part, my lord, there is some overwriting.
Yes.
So therefore, my lord, he was given an opportunity to produce a fresh certificate within 4 days, my lord.
What is the prescribed format?
My lord, the issue is, my lord, we are given issued in this format only. In fact, another person who happens to be his friend, my lord, he had also submitted the same format at annexer 10. He is selected, my lord. His document is accepted and my
What do you say,
document, my
madam?
lord, is not accepted. My lord. That is the limit.
This is signed by the executive magistrate.
Executive magistrate.
Had learned counsel for the parties to petitioner is agreed by the rejection of his candidature by the respondent authorities for being appointed to the post of Constable GT, Constable within bracket GT, in Central Armed Forces, SSF, Rifleman GT in Assam Rifles, and Sepoy in Narcotics Control Bureau. Stop. Petitioner belongs to the unreserved category and is a permanent resident in the district of Karbi Anglong. Pursuant to the selection, in which he had been selected for appointment, petitioner was required to furnish a domicile certificate. Stop. They say domicile certificate was furnished, but the authorities have refused to accept the same on the ground that it is not as per the prescribed format. Stop. Learned counsel to the petitioner submits that the format in which the petitioner has submitted his domicile certificate is the format issued by the competent authority, namely the ADC / Executive Magistrate, Difu, Karbi Anglong. Stop. No other format is issued by the competent authority. That apart, stop. That apart, one of his a similarly situated person who had submitted his domicile certificate has been selected. Stop. The same candidate has also submitted a similar domicile certificate issued by the same executive magistrate, Karbi Anglong. Agreed by the non-consideration of his candidature, petitioner has challenged, prayed for appropriate orders before this court. MS P. Sharma, learned CPC, submits that you'd obtain instructions or we issue notice. You obtain instructions. Prays for 2 weeks' time. 2 weeks to obtain instructions. Matter be listed after 2 weeks. Extra copies of the writ petition be furnished by the learned counsel to the petitioner within 3 working days from today. List after 2 weeks.
But 20 is against the order of discharge, my lord. My grievance, rather than on the marriage at this stage, is that, my lord, there is a provision of appeal under the statute, the Assam Rifles Act, my lord, which I had preferred in Annexer 4. Now more than 1 year has gone by, my lord, nothing has come out of the same, my lord.
Who is for the Assam Rifles?
Right at 20.
Yes, CGC. Your
No.
grievance is that appeal has not been, no orders have been passed in the appeal.
No. It was filed on 10th May 2024. In fact, the statute is peculiar because it does not give any time frame, my lord. As far as section 139 is concerned, no time frame is there.
No, but you are
But then
also
it cannot be
challenging,
indefinite.
you are
my lord.
also challenging the dismissal order.
Yes, my lord. But then, since the statutory appeal is there, that should also, my lord, be considered at this stage.
The Heard Learned Counsel for the parties is petition is by the petitioner, who's aggrieved by the dismissal order issued by the respondent authority, ID. Order dated 4th of June. Dismissal order is 4th June.
My lord. 4th June 2020.
4th June 2020. Stop. It is the grievance of the petitioner that the petitioner is not conversant in English language, and during the inquiry which was conducted, no interpreter was provided to him, and the order as well as the proceedings were conducted in English. So it is submitted that the entire proceedings are contrary to the provisions prescribed to the Assam Rifles Act, read with the rules in their under. It is further submitted that an appeal as prescribed under the statute was preferred by the petitioner against the impugned order of dismissal. So, however, no such order has been passed by the appellate authority. So, if that be so, learned government advocate, learned counsel appearing to the respondent will obtain instructions with regard to the status of the appeal that has been preferred by the petitioner, which is stated to be pending. Stop. These instructions be placed before the court on the next date fixed. Let extra copies be served on the respondent counsel within 3 working days from today. Further orders, if required, will be passed upon the instructions being placed by the court before the court by the respondent counsel, placed on 11 December. 11 December.
Yeah, please. Here is this case, my lord, compassionate appointment, my lord. Petitioner father expired on 2000, my lord, and he applied 31/7/2001. Subsequently, the Honorable High Court passed 2 orders, my lord. Your Lordship may kindly peruse the order of this Honorable Court is at page 39, my lord. Starts from 40, my lord.
Yes.
Same has never been considered, my lord.
What has not been considered?
Not considered, my lord, till date.
No. 39 is the order of the court.
Yes, my lord.
Yes. What was
Directed
it?
them to consider his case, placed in the next DLC matter.
Ah.
Case 41 is the relevant matter. Considering the limited prayer made by the petitioner, as per by the directive to place the case to the petitioner DLC, court is thought that the same can be considered in the next meeting to be held by the DLC. In view of the above judgment and order passed in 2620/2000 for the by the state of Assam, the DLC shall intimate that
His order was passed in 2011.
11, my lord, but never, my lord, was not communicated never, but I have approached before them regularly, my lord.
We have approached. Yes, madam, we obtain the instructions here.
They will obtain instruction, madam, whether they will consider it or not.
The limited prayer before
Yes,
this court is that the petitioner's application is directed to be considered by the court by order dated 24/2011 passed in WPC 4300 of 2010 has not been considered, although the said order was brought to the notice of the respondent authority. So, MSM Bhattacharya, learned government advocate, will obtain instructions in the matter and place it before the court. Matter be listed after 4 weeks. Extra copies be furnished on the learned government advocate within 3 working days from today. Placed after 4 weeks.
Obliged.
For your lordship, the junior engineer at PNRD department, and on 1st of June 2018, he was transferred from Hailakandi, Kathichara Development Block of Hailakandi District to Sunai Development Block of Kachar District. On 2nd of July 2018, she was released. 3rd of July, she reported for duty, but she was not handed over the charge on the plea there. The person who is working at the time of junior engineer, he was engaged in the NRC duty. And since then, my lord, petitioner is hanging. He is not getting a salary also. And petitioner submitted representation.
She was asked to go on voluntary retirement.
And then she prayed that, my lord, since my grievance has not been redressed, and I was not allowed to join anywhere. So, my lord,
No, were you allowed to go on voluntary retirement?
That is a, she made a prayer before the competent authority. Before the competent authority, she made then in the circumstances, I may be allowed to go to PRS.
Then?
Then, my lord, the is pending. So let them take instruction what happened. Some correspondence, departmental correspondence were made with regard to the status condition of the weather. This person was, my lord, I am reading from page.
No, I am not. What is your prayer in the writ petition?
Petition, my lord, to allow her to go for BRS. And my lord, the
BRS cannot be like that. BRS has to be on the basis of some scheme. Is there any scheme?
Yes, ma'am. I have endorsed this. Office memorandum 19.
Where is that office memorandum?
Office memorandum dated, my lord, at page 46 of 12 September 1984. And then, my lord, there is waitage period of the at voluntary retirement office memorandum retirement of the waitage 5 years.
When did you apply for VRS? Where is your application?
My lord, her application, the representation, the first representation of VRS that allow me to go to VRS is at page my lord, annexure 8 on 14/2/2022. At page, my lord, 29, page 30, 31 representation. The entire, she narrated the entire matter, the chronologically event, what happened. Then, my lord, at paragraph 10 at page 31, my lord, she has requested to the department and also to the Chief Minister and the Minister of the PNRD and Deputy Secretary Panchayat and Rural Development. The para 10, therefore, I have decided to go for BRS with immediate effect and earnestly requesting to treat this my BRS application. As I don't have any place of posting, therefore, it is obvious that the BRS shall be proceeded exclusively from the Panchayat and Rural Development School Guwahati, with the hope that entire procedure shall be.
Then what happened after that?
My lord. After
that, what happened?
After that, my lord, on correspondence has been made. She has to the submitted another representation on 34/2022 attached to the Secretary PNRD Department, which is at page 33. Thereafter, my lord, one letter has been issued at page 41.
No, but this is not for VRS.
My lord, this application is same application, my lord, at page 4.10, page 35, para 4.10. Therefore, I have decided to go for BRS with immediate effect and earnestly requesting to treat this my BRS application. As I don't have any place of posting, therefore, it is obvious that the BRS shall be proceeded exclusively from Panchayat and Rural Development School Guwahati with the hope to the entire proceeding. Then, my lord, on page 41, NHR 10, from the Secretary to the Government of Assam Panchayat and Rural Development to the Block Development Officer, Sunai Development Block, regarding transparent posting of some Baharuddin Laskar, then JE Sunai Development Block. With reference to the subject matter, I am directed to request you to submit a formal report whether Sri Baharuddin Laskar, then Sunai Development Kachar, presently South Indian Block, Hailakandi was engaged in NRC work or not, EPS, the period of engagement may be mentioned. So, my lord, this is the after that Secretary has issued a letter to me.
with regard to the status of the applicant. So, my lord, nothing has happened with regard to their representation, specific contention that allow me to go to here. Then, my lord, page 42, Under Secretary to the Government Ashraf, it is a letter of the dated 28
You are asking for VRS, you are asking for your arrear pay.
My lord, I am once I am not allowed to join, then from where I will get my PR? So but definitely, my lord, she was not
I
got
heard
her.
learned counsel for the parties. This petition is filed by the petitioner, who was working as a junior engineer in the Department of Panchayat and Rural Development, Government of Assam. During the services rendered, it is stated that she was not given her salary for the month from the month of July 2018 till date. Stop. Consequently, she filed an application dated 14/2/2022 and 30/04/2022 to allow her to go on voluntary retirement. Stop. However, there is no response from the department as regards the prayer made by the petitioner, and accordingly, a writ petition has been filed praying for suitable orders from this court. Let notice be issued, returnable 4 weeks. Mr. K. Kumar, additional AG. Anything you want to submit today?
Your Lordship, in this, at this stage, Your Lordship.
We are issuing notice.
Notice.
Mr. K. Kumar, learned additional AG, appears for the Panchayat and Rural Development. Steps on the as common advocates have entered appearance on the behalf of the respondents. Notices are waived, however, extra copies be furnished within 3 working days from today. Matter be listed after 4 weeks.
All right.
Please.
Yes.
It is meter according to the proposal of the petitioner rejected by the 14 SLC only on the ground of balance of service.
Yes. What is the status?
Yes, Lordship, I need to get the status, Lord. No, it is already been filed. It is pending.
It is pending.
Yes. Of that judgment.
There is no interim order. Maybe there is no interim order.
It is submitted by the petitioner that his application for seeking appointment under the compassionate scheme, which was submitted pursuant to the demise of his father, was working as an AB constable, has not been considered by the has been rejected by the SLC on the ground that the late father of the petitioner had less than 3 years balance service, and which condition is mentioned in the OM dated 1/6/2015. Stop. It is submitted that a writ petition, a coordinate bench by judgment and order dated so and so, passed in WPC number
1646, Lord.
1646
2021.
2021 and other connected writ petitions. What is the date of the order?
30/01/2020. 31/20.
30
30th January.
30/01/2023 has set aside, has interfered and set aside with the said clause 1 of the OM dated 1/6/2015. Stop. Under such circumstances, the petitioner's case be considered by remanding the matter back to the SLC for fresh consideration. So, MS M. Bhattacharya, learned government advocate, submits that against the said order by the coordinate bench, an appeal has been preferred. However, she prays for time to apprise the court regarding the status of the appeal. List on Friday. Can you get it on Friday? List on Friday.
Wait, please,
Yes.
In this case, the petitioner appeared in combined exam for selection for constable generality under the border security form. Okay?
Yes.
He scored 40 marks in his written exam in BSc category, OBC category, and other persons, the last selected candidate of OBC category also scored 40 marks, but the petitioner was not selected. That is my question.
It was, when was the select list?
Select list was Lordship.
2017.
Yes, Lordship.
So why have you come so late?
Some similar cases are pending, Lordship, and my client entered before the authority that if new vacancy arises, then this person can be accommodated. So, Lordship, I have come before this court lately. The similar cases of 2015 selection is pending till now. Lordship, WBC number 221817 946 17 1.
Who's for the respondent? You belong to which category? OBC?
OBC.
Oh, so what is your grievance that?
My grievance is that the person who I scored 40 marks in the selection, and the person last candidate of OBC, he also scored 40 marks. Therefore, I was deprived from selection, although I am eligible for being selected.
No, you scored higher or lesser?
Equal marks.
Equal marks.
Yes.
So, on what basis you are claiming that your name should be included?
I scored equal marks, therefore I should be considered.
Provided there are vacancies available. There must be vacancies available.
That's true, but there is some provision in the time matter, Lordship. If it is die, then the person who scored more marks in question A paper, he shall be given preference. So,
yes, madam.
Lordship, thereafter 2018 selection process was there, Lordship. There in that selection process there is no vacancy. So now prior to that, and he had approached this court at such a belated stage, may not be possible to consider his case. And he may have equal marks, but at such a belated stage, Lordship.
No, equal marks. How does it ensure appointment?
There is process, Lordship, how to that there is there, but here Lord vacancy is 2018 recruitment process. There is no vacancy. So 2017 must have been filled up long back, Lord.
You get your instruction. You get your instructions. Third learned counsel for the petitioner, that's writ petition, counsel for the parties. The writ petition is filed with the petitioner. Who's aggrieved by his non-selection for appointment to the post of Constable General Duty under the Central Armed Police Forces recruitment. Stop. It is submitted that the petitioner is an OBC candidate and he had appeared in the selection process and was successful. Stop. It is submitted that the last selected candidate in the select list scored equal marks to the petitioner, but the petitioner, in spite, was denied his selection, selection, although he belongs to the OBC category. He therefore challenges he therefore approaches this court praying for appropriate orders to the respondents for a direction to consider his case for appointment in the state recruitment process. Stop. MSP Sharma learned CGC is permitted to obtain required instructions with regard to the issues raised in the writ petition. She will furnish the instructions within 3 weeks from today. Extra copies be furnished to the government advocate. List after 3 weeks.
Well,
After so many years,
I told that but they agreed therefore he has come.
he must have said, let the court say it. No. All right, after 3 weeks.
Whether item may be taken after some time. This is where is another court.
At 2.
In this case, my lord, instruction is necessary.
At 2 p.m. Yes.
Lordship,
Some amended petition has been filed.
Lordship, copy not served.
Not served. None appears for the petitioner. Mr. J.K. Goswami and Mr. R. Hazurika appears for the respondents who submits that copies of the amended writ petition has not been furnished as on date. Matter be listed after 1 week. Yes, Mr. Bhuyan.
May I please, your lordship? My lord, what has happened, my lord? This petition was filed for the, my lord, challenging the selection and appointment of the private respondent as the, my lord, Gaonbura. My lord, our case was that, my lord, though we have, my lord, been called for the interview, but proper interview was not assessed. Now, my lord, the affidavit has been filed, wherein, my lord,
You were supposed to obtain instructions
Yes,
whether
my lord.
you
Yes,
wanted to pursue the writ petition.
Yes, my lord. What has happened, my lord? I have contacted with my petitioner, my lord, and he has verbally instructed, my lord, but that verbal instruction is nowadays risky, my lord.
Verbal instructions for what?
My lord, not to press, my lord. So,
You
my
get
lord,
it.
That's why, my
Get the
lord, I
written
am
instruction.
just, my lord,
We will record it.
sometime it is risky, my lord. May I pray for a last 1 week time, my lord? Take in proper instruction, my lord.
He doesn't want to be convinced.
My lord.
All right. List on Friday?
Yes, sir.
Friday. Mr. Bhuya appears for the petitioner who submits that instructions are reviewed. And he prays that the matter be listed on Monday. Let it be on Monday. Or not Monday. It will be then on 15th. 15th.
Holiday will be the holiday.
15th. 15th is not holiday. And Mr. J.K. Goswami and Mr. Hendik, J. Hendik appears for the respondents. And Mr. Ihawk appears for the private respondent. Mr. Hendik is appearing for respondents for the revenue department. The respondent 1, Mr. J.K. Goswami for respondent 2 and 3, Mr. Ihawk for respondent 4. Matter be listed on 15th. 15th.
In this case, in spite of granting of so many times to a respondent, they are not filing counter affidavit. Your Lordship may please to see the order dated 24/7. They have received the instruction as per both counsel appear. Next date, another counsel appeared, 24/7 to 20. So NAYA license may be granted to them for 4 weeks after matter.
None appears for the respondents. Who are the respondents?
Forest Department and PTC, both are
Who is supposed to file?
both. Important is Forest Department.
All right, none appears for the Mr. Maheshwari appears for the petitioner. None appears for the respondents when the matter is called. As per earlier orders, the respondents were required to file their response. However, no such response has been filed, and none represents the petitioners. Matter be listed again on Friday. Friday?
Not Friday, Monday, Thursday.
15th. Will be listed again on 15th. Names of the respondent councils will be reflected in the cause list by the registry.
I submit.
Yes.
I want to withdraw this petition.
As per the submission made by the Learned Counsel, Mr.
MDM Hawk.
M.
MDM Hawk.
MDM Hawk, counsel for the petitioner. Matter stands dismissed on withdrawal. Interim order, if any, stands vacated. Mr. J. Hendig appears for the Revenue Department. Mr. J.K. Goswami for the respondents. Number. Mr. J. Hendig appears for 1, 2, and 3. And J.K. Goswami for respondent 4 and 5. None appears for the private respondent. Interim order, if any, stands vacated.
Apply.
Yes.
Apply. The dispute arose, we have issued the notice, my lord, to appoint arbitrator. But they have not appointed, my lord. It can be appointed, my lord, as per their terms also, my lord. Clause 64, my lord, is here. Page 57, my lord.
$57.
51, my lord. Sorry. It is 51. Looks like.
Clause?
Yes.
Clause number?
64(3)(A)(1). One to second, my
Yes.
they can appoint an arbitrator, my lord,
Have you filed an application?
Yes, my lord, notice has been issued, my lord.
No,
That is
no,
at
for
page
appoint for
101, my lord, 101.
101.
10. That was issued long back, my lord. 3/3/22.
Yes, what do you say?
Lordship, as per my affidavit, Lordship, before the 7 days period issuing of notice and 48 hours notice, Lordship, they had written a letter for foreclosure of the contract, Lordship. And this, as per my affidavit, Lordship, this is an accepted matter, Lordship. So in case of accepted matters, Lordship, as per the general clause of contract, Lordship, clause 8, Lordship, now the decision of the authorities is final, Lordship. May kindly take up page 120, continuation page 120. Start from page 119, Lordship, paragraph 24.
Yes.
So and so, Lordship, so our deponent states that as per general condition of contract agreement, all dispute and differences of any kind whatsoever arising out of or in connection with a contract, whether during the progress of work or after its completion, and whether before or after the termination of the contract, shall be referred by the contractor to the GM, and GM shall within 120 days after receipt of the contractor representation make and notify decision on all matter referred by the contractor in writing, provided that matters for which provision has been made in clauses 8 so and so of standard general condition of contract or in any clause of the special condition of the contract shall be deemed as accepted matters, and decision of the railway authority thereon shall be final and binding to the contractor, provided further that accepted matters shall stand specifically excluded from the purview of the arbitration clause.
My lord, under section, under clause 63, we have issued the notice, page 78. They have not taken any decision. How they can say it now? Page 78. That is that clause 63, my lord. Later, my lord. The general manager has to take a decision, my lord, first. They have not taken decision. That is why we have gone for 64. So let the arbiter decide to let them take a point, my lord, in their written statement.
No, where is it referred? Accepted matter?
Yes.
Lordship, here, Lordship, only one. I have to place the whole agreement, Lordship, in that case, Lordship, that general clause of contract. At present, the whole.
No, you are saying that this is what?
Accepted matter.
Why is it an accepted matter?
Because it is in the clause, general clauses of contract, Lordship, that is arbitration, that is at present is.
My lord, that is provided in page 50, clause 63(1). But the general manager has not taken any decision under our interpretation, my lord. He has to take a decision first. He has not taken a decision. So the matter is to be referred to the arbitrator. Arbitrator can consider it.
Because before that issuance of notice, Lordship, he had submitted representation for foreclosure. So when he himself has submitted a representation from foreclosure, that comes under accepted matters, Lordship.
Where is that application for foreclosure?
Lordship. Yes, Lordship. I have annexed that 9.
You submitted any application for foreclosure?
No, that was earlier, my lord, maybe, my lord, that is not the question, my lord, here. But as per section clause 63(1), the general manager has to pass an order. Has he passed any order under our repression? Not. Our repression is detailed repression, page 78. As per clause 63(1), the general manager has to pass an order. Make and notify the decision on all matters referred by the contractor in writing. In 128.
68 and 59 of the writ petition, Lordship. That is the 9311. 9321.
On this representation, what orders were passed?
No order.
Any decision was taken?
No. This 78 is a detailed representation, my lord. We have
So he submitted it on 9/3/11. We have on 10/3/21, we submitted, we sent him a 48 hours notice, but that is the unsatisfactory response, Lordship, and then subsequently the contract was terminated.
Then nothing is there, my lord.
Before that time is concluded, Lordship, that foreclosure notice was there. He himself has submitted for foreclosure. And now they are,
Now, what are the consequences of foreclosure
now, as per that
under the contract?
contract, Lordship, that comes under accepted measures and decision of the authorities are final. It's not an arbitrable clause. That
By the decision of the, my lord, the authority. And our representation, no decision has been given by the authority. And that has been ignored. We have issued the letter for foreclosure, but that is ignored. They issued 48 hours notice. That has not been considered at all.
In your response dated 10/3, there is no reference to this letter given by the petitioner for foreclosure.
Lordship, that is 68 and 69 of the writ petition.
No, 68, 69 is the application given by the petitioner for foreclosure.
Yes.
In your response at page 71,
Lordship,
where you have given him 48 hours notice, there is no reference to the foreclosure.
Yes.
There is no reference.
No reference.
but that is admitted, Lordship, next year. It
Huh?
may not be. It may not be in the 10/3/11/21, Lordship, but here they have annexed that later, page 68 and 69.
Who is annexed?
Petition.
No. It is their case. It is your case that they have submitted an application for foreclosure. Now, foreclosure is an exempted matter, so therefore, there is no question of arbitration. But whether you have accepted this foreclosure or not, what consequences will follow, there has to be some decision by the authority. Instead, what you have done is you have issued a letter dated 10/3,
Yes, that
giving him 48 hours, and thereafter you have terminated.
Yes, sir. We have given him that opportunity also. 10/3. Hence, 48 hours notice was issued on 10/3/21. Due to non-progress of work, railway sustained financial loss on this account. This is a time-bound national project where delay in completion of work is answerable to ministry. Therefore, the work has been terminated to compensate the loss sustained by the railway.
And that was ignored, my lord. What's the consequences of that?
Lordship, then paragraph 20, we have stated that after issue of 48 hours notice, there was no satisfactory mobilization on the part of the agency, even after
No,
expiry of 48
now
hours.
arbitration to decide what? What do you want? What is the issue that you want?
Claims, my lord. Our claims are there. We have said. We have given in the notice, my lord, that page 104. These are the laws we have suffered.
Take us to the clause again, the arbitration clause.
Yes. Arbitration clause is 64, my lord, at page 51. 64(3)(a)(1). In cases where total value of all claims.
Page number?
Page 51.
51.
Last but one, madam.
Yes.
Last but one, 64(3)(a)(1). In cases where the total value of all the claims in question added together does not exceed ₹1 crore, the arbitral tribunal shall consist of sole arbiter who shall be a gazetted officer of the railway, not below the junior administrative grade, nominated by the general manager. The sole arbiter be appointed within 60 days from the day on which.
And what are the issues to be decided? What are the exempted
claims?
issues? Exempted issues?
Exempted, my lord, that letter has not been considered at all.
Exempted is
no question of exemption, my lord.
That is not their, Lordship. The whole agreement is not annexed, Lordship. Clauses 62, 61, 62, there are exempted measures. If it is not
No, on what basis are you saying that? It must be provided in the arbitrator, the act, the contract.
That is why, Lordship. On the next date, I will place the complete agreement, Lord.
All right.
Clause.
When do you want it?
On next
Day,
Monday.
day after tomorrow, my lord.
Day after tomorrow. Lord.
Let us have it on 14th. We can have it on 9th. 9th? 9th? Or at least on 9th, on which date the Council for the Railways will furnish the contract agreement executed by and between the petitioner and the.
Not general clauses of contract. That is for all arbitration. General clause of contract.
Pertaining to this contract.
Not only, Lordship, for all.
We
That
don't
is-
know.
that is general.
We are concerned with this. We want your documents with regard to this.
Because that will come only from that only.
We'll produce. We'd like to furnish our instructions and necessary documents for in support of our contentions that the prayer for arbitration cannot be accepted in view of the issues being covered within court's accepted matters. Mr. Saiwala appears for the petitioner. Matter be listed again on 9th November.
Lordship, kindly pass over the case for timing as my seniors and leaves
What is the matter?
for promotion.
We have filed the affidavit, my lord. Let them file reply if then.
But they've not made any prayer. Already passed over. Yes.
Here the petitioner participated in a selection process for the post of staff nurse.
Well, the affidavit is already ready, my lord. I pray for at least a week's time to file it. It's ready,
Mr. B. Gogoi, Learned Counsel
On
for the
behalf of respondent
Health,
number 2.
submits that he'd like to file the affidavit within a week's time. Mr. Ahmed, Learned Counsel for the petitioner, does not object. You're Mr. Loskor.
M. Ahmed.
M. Ahmed does not object to the prayer meeting. List after 1 week.
Hello.
Please, Lordship. Lordship, according to last order dated 29/9/2023.
Yes, counter affidavit not filed, Mr. Goswami. You are given time to file affidavit as per last order. No affidavit filed. Mr. Nath?
But the affidavit in opposition of respondent number 4 and 5 is filed.
Huh?
Oh.
On behalf of respondent 1.
1. So that is the price.
Mr. D. Nath, Learned Government Advocate, Senior Government Advocate, prays for and is granted 2 weeks further time to file the affidavit as directed earlier by the court on behalf of respondent number 1. Your name?
Yes, Gautam, my lord.
S.
Gautam.
Gautam appears for the petitioner. List after 2 weeks.
Already date may be fixed. Date may be.
Let him file the affidavit.
May it please your lordship, my lord, the petitioner before your lordship is a physically disabled man. He is working in the health department, my lord. In the year 2010, my lord, 3 months, he was transferred in a different setup, that is the medical education department. Directorate of Medical Education, but he was not released because of his physical disability, and he worked in the Director of Health Services. But that particular later on, my lord, his transfer order was stayed, but fact remains that for the month of June, July, August, September, his salary was not paid. By that way, my lord, there is a break in service. My lord, I am before your lordship, my lord, for payment of that particular period salary and to regularize that period, my lord. My learned friend has received the instruction also, and I have filed additional affidavit in this regard, my lord. There is a document at Annexure A, my lord. If lordship can go through this annexure, the fact will be clear. If I
Page 36.
yes, my lord, page 30. May I read, my lord?
Yes.
There is a letter from the Director of Health Services to the government, my lord. With reference to the subject cited above, I have the honor to inform government that the Hiranya Medhi, holding the post of Superintendent Account Branch of the Directorate at present, filed a writ petition in the Honorable Guwahati High Court for non-payment of salary for the month of June, area increment dues rupees 700, and salary for the month of July, August, September 2010. Regularization of his service for the break period. The matter came up for consideration before the Honorable Court. The petitioner is a physically disabled person having post-polio residual paralysis of left lower limb and weakness right upper arms with 50% physical disability. The petitioner was first appointed at LDA, now designated as junior assistant, in the year 1988 on ad hoc basis and regularized by order dated 16/9/1989. In this regard, it is to inform government that Sri Hiranya Medhi, the junior assistant promoted to the post of senior assistant by Directorate Order Number so-and-so dated 2/6/2010, with place of posting in the office of the DHS Assam, and accordingly he joined in this directorate as senior assistant on 3/6/2010 as per promotion order. Subsequently, a transfer order dated 14/6/2010 was issued and he was placed against a vacant post of senior assistant by Sri Lakhikanta Basumatari in the office of the Director of Medical Education, Assam. He continues to work in the drugs branch of this directorate, and he could not join in the office of the Director of Medical Education, Assam, and follow the order. But in the greater interest of public service, being physically disabled employee, as per decision of the screening committee of this directorate, his transfer order was stayed by Directorate Order Number so-and-so dated 14/12/2010. As a result, his pay and allowances could not be drawn for the month of June, only area increment, and salary for the month of July, August, and September 2010 because of non-availability of vacant post of senior assistant in this directorate. However, with effect from 1st October 2010, Sri Hiranya Medhi was accommodated in this directorate when a vacancy of senior assistant occurred in this directorate. He is drawing salary and allowances regularly from 1st October 2010 to till date regularly. The basic crux of this case is that the petitioner was not paid the salary for the month of June, only area and incumbent, July, August, September, and 2010. During the said 3 months, the salary could not be paid from the establishment of DHS Assam because non-availability of vacant post of senior assistant. However, the post was lying vacant in the office of the DME Assam. The petitioner is facing problem because of non-payment of salary for those 3 months despite rendering of service, but also creating problem in his service career, as said 3 months shall be treated as break in service and may cause serious problem in payment of retirement benefit and regular pension. Be it stated herein that the petitioner will be retiring from service on 30th November 2023.
Now there is an admission that there was a post vacant.
Yes, in the
Yes.
DME below.
That instruction I have also received.
Then you take steps to regularize that period.
Yes. And the bottom of this page, Milord, they have given the calculation, the payment of amount of salaries for the month of June, 700 rupees, July, 20,433, August, 20,433.
Pursuant to this communication, what steps have been taken?
I have communicated to the director. Director has given sending letter to the government. And thereafter, that is
You get the instructions from the government. He's retiring on November 30.
My lord, since there is nothing adversarial, my lord, Lordship may dispose it of because on 30th November I'm retiring.
Hmm.
The Lordship can dispose of the matter because director has no any other case taken.
No. What is your prayer here?
My prayer is to pay the salary for this period and regularize the break service. My lord, in DME Assam, there was a post vacant, but I could not join there because of my physical disabilities. But I rendered service in DHS, not in DME.
Without there being a post.
Without there being a post. That
You
is
are,
why I could
where
not
is
be
your
paid.
appointment order?
Pardon?
Where is your appointment order?
First appointment letter is page 16, my lord. And then, my lord, regularization is, then promotion order is page 26, 2010, page 18. Physically handicapped certificate is at page, my lord, 15 and 16. But there is no dispute anywhere, my lord, only because that I rendered service in a place where there was no post.
Okay. Heard learned counsel for the parties. This petition is filed with the petitioner, who is an employee under the Directorate Department of Health and Family Welfare. Stop. The petitioner was initially appointed as a junior assistant, within bracket formerly known as LDA, and he was posted in the office of the under the Directorate of, where were you posted?
Now, my lord, in the
No, then
DME, Directorate of Medical Education, when he was transferred.
No, on 16 September 89,
Since his appointment, he is in Directorate of Health Services only.
Directorate of Health Services was appointed under the Directorate of Health Services. Subsequently, the petitioner was promoted to the post of senior assistant under the Directorate of Health Services. Stop. Thereafter, by order dated 14/6/2010, the petitioner was transferred and posted in the office of Director Medical Education. Stop. Subsequently, the petitioner's case was considered and he was promoted to the post of superintendent by order dated 1/6/2010. Stop. Although the petitioner was transferred to the office of the DME, he could not join the said post because of his physical disability, as stated. Stop. Necessary representations were furnished before the authority concerned. Stop. Subsequently, the taking note of the applications filed by the petitioner, the transfer order was stayed by order dated 4/12/2010. Stop. Since then, he has been rendering services in the DHS. Stop. Since the petitioner could not join in his place of posting as transferred earlier, his salary and pay and allowances for the months of July, August, September 2010 would not be made available due to the lack of the vacant post of senior assistant under the Directorate of Health Service. Stop. Your promotion, was it state earlier?
No. When I was promoted, I immediately joined in my same director. That is discernible from the communication of the director. Then I was transferred after 2 or 3 days.
What is the order at page number 32?
Page number?
32.
This is a promotion order of superintendent. I am now superintendent. From senior assistant to superintendent.
And what is the order at 21?
This is a transfer. This is a promotion order of some person against whom, my lord, I was adjusted. Lakhikanta Bosumutari, he was promoted to a upper divisional post, upper post. Then I was adjusted in his place.
8th of December 2021. So, the petitioner, it is submitted that the petitioner is going to superannuate on 30/11/2023. 30 November is retiring.
My retire.
So there is an apprehension that because of non-release of his pay and allowances for the months of July, August, and September,
Period from June to September.
June to September 2010 may be treated to be break in service, and therefore the same will affect the release of his pay and retirement benefits. So, where IMS S. Sharma, Standing Council, submits that there is no dispute that the petitioner had rendered services, but the salary and pay and allowances for the said period was not released to the petitioner. So, having heard learned counsels for the party, we have seen that in an additional affidavit by the petitioner, communication dated 11/4/2023 was issued by the Director Health Service to the Secretary Health and Family Welfare, wherein it is stated that because of his physical ailment, physical disability, petitioner continued to work under the Directorate of Health Services and could not join in the office of the Director of Medical Education as per the transfer order dated 14/6/2010. Stop. The said order was subsequently altered and modified. Stop. Although he continued to render his services under the Director of Health Service under the drugs branch, his pay and allowances for and salary for July, August, and September 2010 would not be released because of non-availability of vacant post of senior assistant under the state director. Subsequently, in view of a vacancy which arose, view of a vacancy of senior assistant which arose from the month of October 2010, the petitioner was accommodated and is drawing his salary and allowances regularly. Stop. It is seen that the department does not dispute the contention raised by the petition. Stop. The only question that remains is regularization of his services which he had rendered for the months of July, August, and September 2010, and release of the pay and allowances thereto. Stop. In view of the communication dated 11/4/2023 issued by the Director Health Service, since there is no dispute that the petitioner had rendered services as a senior assistant under the Directorate of Health Service, for the months of July, August, and September 2010. He is entitled to his pay and allowances. Stop. The department has altered or modified the transfer order issued subsequently, taking a sympathetic view on the application for representation made. Stop. Under such circumstances, non-release of the pay and allowances for the months July to September 2010,
June to September.
June to September 10, for which services have been rendered by the petitioner, besides denying him his due salary, will also have the effect of creating a break in service for the petition, and which will ultimately affect his claim for pensionary benefit. So, in such circumstances, the respondents are directed pass necessary orders by regularizing his services rendered for the months of June to September 2010, and which services he had rendered has not been denied by the department. So, the department, more particularly the Principal Secretary, Government of Assam Health and Family Welfare Department, will process the claims of the petition for regularizing his period of rendering services for the months of June, July, August, September 2010, for release of his outstanding salary and pay and allowances, if required, as per the provisions of law, if required, by
creating a supernumerary
post for the following, for the 8 months of June, July, August, and September 2010. So, with effect from October 2010, the petitioner salary is adjusted is accommodated against a vacancy of senior assistant which had occurred under the department. So, the directions above shall be carried out immediately by the department in order that the petitioner is granted his due pensionary benefits as and when he retires.
I'm obliged.
Writ petition stands disposed of in terms of the above. No order is to cost. Interim order, if any, stands merged. Pending I is also vacated.
Obliged.
Yes. Pending I is also stand. There is no I.
No, is no I.
There's no I.
Obliged.
Yes.
May I please lordship? Before starting my lord, before my senior starts my lord, I want to inform court my lord. Today I have filed one IA my lord in this matter to import imprisonment my lord. And a copy has been already served to the petitioner my lord. Today is not before listed your lordship, but my is very necessary my lord. Party respondent.
Impleading whom?
I am also a candidate my lord, who is more suitable than the petitioner for the post of the.
Oh, you are a person, you are a candidate.
Yes, ma'am. I'm senior to the petitioner, ma'am. And I have all the eligibility criteria.
Maybe, but you'll have to be first impleaded.
Yes, my lord.
Your impleadment petition is not here. When did you file it?
Today, my lord.
Why?
Today, my lord. Because of some particular difficulty. But it will be taken up on day after tomorrow.
Let's say for 7 years, no one was there. Now someone comes. Anyway, let the application come before my lord. And I have
Is
been
that
served.
bifurcation? Is it that bifurcation?
Yes, lordship.
Bifurcation.
That matter.
What was the order passed by the some?
It's pending.
Division bench, lordship, in fact, on many occasions wanted to dismiss the review, but because the learned government council wanted to take some instruction, he was granted time. And in the contempt, lordship, order has been passed that personal appearance will be given of the contempt.
Review is pending, isn't it?
It's pending. It's pending.
So let the application be listed next week. Next week.
One thing.
Yes. And in the meantime, lordship, if I may be allowed to file my affidavit today.
Yes, yes.
My lord, the eligibility of the petition, my lord, this may become a factor in the division bench. Just pointed out, my lord. Page 30, my lord, it starts from page 29.
Yes.
My lord, if my lordship comes to 3.2, senior grade, it's joint director, chief geologist. Then the word chief drilling engineer was added in 1990. And lordship sees 5.1 down below, my lord, 29 itself down below. The post of director shall be filled up by promotion from the cadre of joint director, chief geologist, chief drilling engineer. My lord, we'll read the word chief drilling engineer into that because that was amended subsequently. Now, what was not amended is in page 30B.
33.
30, page 30, B.
B.
In order to become eligible for promotion, the incumbent must have at least 20 years of experience with minimum 3 years as joint director, chief geologist. My lord will read into that also, that chief drilling engineer on the first day of year in which the selection is made. Experience in administration of mineral groundwater exploration activity in the part of so-and-so, so a post of for 5 years. Experience of geological field survey as well as supervision and guidance of mineral groundwater exploration for at least 5 years. Or experience in mineral administration works of minerals and mineral oil concession capacity of 5 years. As
anyway, these will all be subject to the review.
Because this is what is missing out, Mala. That was not taken into consideration.
So
Maybe
let the
that
I
is the
be
reason.
listed, and you want to file what?
I'll file if the petitioner wants lordship. Then
Let
maybe,
the I be listed then.
yes, let the I be listed.
On Friday? You want it on Friday or next week?
Let it be
Next week. All right.
Much of it.
At least next week.
Then lordship fix a date if lordship pleases.
Give a date. 15th.
Lordship. Obliged.
Something like I okay.
Lord, in this case, we have to file an amended petition, Lord.
Amended contempt petition.
Lordship, in that petition is that the earlier the contempt was filed against the Ramsur Bajaj, he left out the company. Then they have mentioned that. So his name should be struck off the new director against which the notice must go.
Because of the fact that one person has left the company, he will not be absolved from the contempt proceedings if he has committed some mistake. I don't understand.
You want to file a what? You want to file a?
No, another contender has been added. So we have to file that amended petition.
Mr. E. Dasgupta.
Just I want to submit one in the paragraph that is mentioned. Paragraph number 4 in the IA, during pendency of the proceeding, the previous container has left the company.
Yes,
The,
left the company.
matter is against the company. Suppose the payment. So the new director who is implemented, he will reply all the things whether the payment has been made or not. Why the earlier director should be in the
Earlier director, if during the, if it can be shown that when the order was passed in the writ petition, is it a writ petition?
He has left out the company on 30/4/2018.
Was he there in the company when the order of the writ court was passed?
Yes.
So you'll have to satisfy that on the day or after the order was passed, there was no deliberate willful violation.
This IA contempt was filed in September.
Maybe
2009,
contempt.
2018.
The contempt is to find out whether there is a willful or deliberate disobedience of the orders of the court passed in the writ petition. So on the date when the writ petition order was passed, was he a director?
That payment, that represent that he was the director.
Then
Lordship, the payment was made along. In their payment
so that we'll hear it in the appeal.
He's an old person, and the new director which will be implemented, he will clarify all the things whether the payment was from the beginning, because there is an admission from which after his
Notwithstanding that he has committed a contempt.
Yes.
Assuming he had committed a contempt.
During his part, 2000, he was made the payment. That is in here.
That will hear it. That will
hear
it. That will hear it. If not required, we'll strike off his name. If not required, we'll strike off his name. That's all. It is submitted by Mr. A. Dasgupta that amended petition is required to be filed. Contempt petition. He prays for 4 weeks' time. Mr. P. Sharma appears for the respondent. You appear for the respondent.
Only Ramswarup Bajaj. I'm appearing for the only
Earlier director.
Earlier case.
Content number 1.
That is respondent number 1. Matter be listed after 4 weeks. Yes.
May I please, your lordship, my lord, this review petition has been filed praying for review of the order dated 11/5/2022, my lord, at page 13, my lord. The contention of the review application is that, my lord, the proper facts was not placed before your lordship, my lord, because in the order passed by your lordship, after observing all the facts, my lord, your lordship has been pleased to direct at page 15, paragraph 9, my lord, the operative portion, my lord. Page 15, paragraph 9. Having heard the learned counsel for the parties as well as the learned government advocate appearing for the state respondents, this court is of the opinion that the
service report is awaited as per office note.
Yes, my lord. Yes.
As per office note dated 26/10/2013. Service report on respondent 1 and 3 is awaited. List after 2 weeks.
Obliged, my lord.
Unless you want to take Dusty, you have taken Dusty. You want to take
My
Dusty.
lord, it's not possible because that person is not there in the
Very
post,
well,
my
very
lord.
well.
Yes, sir.
Made in the lordship, my lord, I am for the petitioner in the writ petition. The petition along with that IA filed by them both has become infractuous.
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 It is submitted by the learned counsel, Mr. P. K. Roy Chaudhary, that writ petition along with the IA has become infractuous. Mr. J. K. Goswami appears for the respondent. Mr. Mr. B. J. Handick appears for respondents 1 and 2. Mr. J. K.
4, 5,
Goswami
6, 7, and 8,
appears
9.
for respondents 5, 6, 7.
4, 5, 6, 7, 8, 9.
4, 5, 6, 7, 8, 9. Mr. B. Gogoi for respondents 10. Anyone for 11, 12? Mr. Handick also appears for 11 and 12. It's submitted that the writ petition has become infructuous and therefore the matter stands dismissed. Matter is dismissed. What was the prayer made here?
My lord, prayer made, it happened as such, my lord. I was terminated from service. I filed an appeal. Appeal was, my lord, rejected. I came for before the writ court.
All right.
Writ court give a
It was
direction for
dismissed.
modifying it.
Interim order, if any, stands vacated.
My lord, if your lordship, because they, in pursuance to the court's direction, they have modified the impugned order. So, my lord, if your lordship places it as dismissed, it may go on the other side. If your lordship say dispose of, non-dispose, because they have, in pursuance to 11-8, order dated 11-8.
Dismissed as not pressed. That's all. We are saying dismissed as not pressed. IA also dismissed. It is submitted that the pursuant to the applications, representation, or what? Appeal.
Appeal, there was a direction, appeal, my lord, which went against me, against the termination order. I filed a writ. There was a direction to.
Submitted that in terms of the orders passed by this court, dated
11-8-22.
11/8/22, passed in WPC
4/2/22.
4/2/22. Is it a part of the writ petition?
My lord, this is the writ petition. One of the new writ petition which is pending, my lord, is 7/4/12/22.
No. You said the punishment order was modified.
Modified, and again we have filed a writ petition challenging that.
All right. Pursuant to orders passed by this court on 11/8/2022, passed in this writ petition. The earlier order of punishment has been altered, which is under challenge by way of a fresh writ petition.
Numbering 7/4/12/22.
None appears passed over.
Lordship, this is a content application, manner. For violation of two honorable court's order. One is at page 85, another is at your lordship, page 103. Today they have filed one.
You have been served a copy.
Yes, Lord. Yes, just now, few minutes back, your lordship, may I pray for a short date because the girl chair has been
Ms.
deprived.
B. Bhuiyan, learned senior counsel, assisted by Ms.
Ibora.
B. Bora, submits that the respondents have filed an affidavit and served a copy in court today. Ms. R. Kapoti appears for the respondents. Matter be listed again after 2 weeks.
Lordship on 16, can it be? 16.
Why?
Girl child has been deprived from love and care of her father, registered petition.
Let it be on 16.
16.
17.
17, not my tenure will not be available.
Huh?
My tenure will not be available on 17. 16 or
Or 18th,
18 is Saturday.
working Saturday.
Oh,
21.
Lordship, then on 20th,
Let it be on
Monday, 20th, Lordship. 20.
20. All right. You don't want to work on a Saturday, right? On 20.
Obliged. If required, we'll file a reply.
A reply, if required, will maybe rejoinder reply, if required, maybe by the petition.
My lord, this matter relates to premature retirement of the petitioner as a tester in irrigation department.
Where is the order of the court?
My lord, Annexer 1, my lord, page 16, my lord.
What was the direction?
My lord, direction is paragraph 17, 18, page 27, my lord, relevant portion. Here, my lord, 17, may I read, my lord? 17, para, page 27.
Yes.
My lord, thus, from subsidiary rule 8C and from the above decision, it is found settled that the state has the authority and the power to refuse the date of birth of a government employee, even though a different date of birth was accepted by the government at the time of appointment, but such a decision can be taken only after an inquiry undertaken in conformity with the principles of natural justice and fair play. In the inquiry, the employee must have to be given a fair opportunity of meeting the case, and the principles of natural justice must have to be followed strictly, as the decision sought to be passed is likely to visit the employee with civil consequences. It is settled that an inquiry is to be conducted against any person with strict adherence to the statutory provisions and principles of natural justice. In such an inquiry, the employer should take steps at first to lead evidence and give an opportunity to the employee to examine the witnesses of the employer. Only thereafter, the employee is to be asked whether he wants to lead any evidence and asked to give any explanation about the next, my lord. 18 para, from the discussions made in relation to the facts and circumstances obtaining in the case, it has clearly emerged that before the petitioner was made to retire from service on superannuation by the impugn order, that at 8/12/2016, the petitioner was not afforded any opportunity to meet the case of the state, whereby the state respondent had refixed the date of birth of the petitioner in the service book on to 2/1/55 from 2/3/1957, already recorded in the service book as far back as in the year 1988. Any decision to refix the date of birth of the petitioner already recorded in the service book about 3 decades earlier, the petitioner has a right to be heard before making such refixation in respect of his date of birth, and as such, an opportunity of hearing is not afforded, denied to the petitioner. The impugn order is clearly in breach of the principles of natural justice. Next, my lord, paragraph 19, having regard to the events that have preceded the impugn order dated 8/12/2016, this court is of the unhesitant view that there is violation of the principles of natural justice in the form of denial of prior opportunity of hearing before the petitioner had been made to retire suddenly from service on superannuation by the impugn order dated 8/12/2016. In such view of the matter, the impugn order dated 8/12 is liable to be set aside, and it is accordingly set aside. As a corollary, the consequential decision to make recovery of an amount of 7,41,000 towards overdrawal of pay and allowances by the petitioner for the period of alleged overstay from 1 to 2015 to 30 is also set aside. My lord, this is the relevant portion 20, my lord. It is iterated at the cost of repetition. The case hearing is that the employer of the employee, that is the petitioner, has sought to refix the date of birth of the petitioner by changing the same from 2/3/57, already recorded in the service book of the petitioner a long years earlier, to 2/1/1955. As has been observed above, the state has the authority and the power to refix the date of birth
No,
of the
so
government
what is
employee.
violated? So what is violated?
My lord, within 3 months, they should they must be complete. They must complete the inquiry.
If they have taken a decision,
They have not made any inquiry.
then
They have not made any inquiry, and within 2 months from the death, if they fail to make any inquiry, then within 2 months from the death of judgment, they will have to release entire pensionary benefits as per the survey, the date of birth recorded in survey. That is in this paragraph. I may have the last paragraph. Within 3 months, they will have to complete within 3 months, because it is 28 years back. My date of birth was corrected at the initial stage.
alleging willful disobedience of the judgment and order passed by this court, dated 30/08/2022, passed in WPC number 702 of 2018. One of the present contempt petition has been filed with the petitioner, stopped by the said order dated so and so. This court had set aside the impugned order dated 8/12/2016, as along with the decision to recover the amount of rupees 7,41,343 towards drawal of pay and allowances for the period of alleged overstay from 1/2/2015 to 30/11/2016. It was further directed that if no decision is taken by the state government to proceed with an inquiry, right? It was further directed that in the event the government desires to prefix the date of birth of the petitioner, then the same should be done upon by conducting a proper inquiry, which should be completed within a period of 3 months from the date of the judgment and order. In the event no such inquiry is conducted, then the pension and other retirement benefit of the petitioner should be finalized and the entire dues be disbursed to the petitioner within a period of 2 months from the date of the judgment. So, Learned Counsel for the petitioner submits that in spite of the order being brought to the notice of the petitioner, the pension as directed has not been released. Therefore, the contempt petition has been filed. Let notice be issued, returnable 4 weeks, steps on respondents by registered post AD within 1 week from today. List after 4 weeks. Mr. S. Sharma appears for the petitioner. After 4 weeks.
Master.
May I please, Your Lordship. This is contempt petition for non-compliance of the order, Lordship. Lordship, kindly see annexed to relevant portion 13, page 13, Lordship.
Page?
Page 13, Lordship. Middle portion.
1-3.
Yes, Lordship. May I read, Lordship?
4 weeks.
Yes.
It has not been passed.
Yes, Lord.
You have filed representation.
Yes, Lord. Kindly see annexed 1, page number 18, Lord. 8, Lordship.
You are alleging disobedience of the order dated 29/5.
29/5, 26.
Learned Counsel. Contempt petition is filed alleging willful disobedience of the order dated 29/5/2023, passed in contempt petition number 12 by the state order. The representation filed with the petitioner was directed to be disposed of with a speaking order within a period of 4 weeks. So, it is submitted that the said directions have not been complied with, and therefore contempt petition has been filed. Let notice be issued returnable 4 weeks. Steps on respondents by registered post AD within 1 week from today. List after 4 weeks. Yes, Mr. Chaudhary, we had gone through, we are about to dictate, then we realized that the records are not available.
Lordship, I have.
Ah.
But Lordship, perhaps it's in Hindi.
Will have to be translated.
I have flag marked the inquiry.
Itu all right. We'll
Pink flag, Lordship.
Pink flag.
Pink.
What is that? That is the report.
That's the inquiry report.
This matter was heard and judgment was reserved. However, subsequently, the original reports that were required for perusal of the court were found not to be available. Therefore, the matter was listed today. Mr. R.K. Dev Chaudhary, learned DSGI, has submitted the original records pertaining to the disciplinary proceedings conducted against the petition. So, on perusal of the record, it is found that they are in Hindi. Therefore, the registry is directed to translate the report you see, translate into English. So, matter be listed again after 4 weeks. We are keeping it after 4 weeks. And it appeared for the writ petition. Please recording. Yes. Where are the other councils?
This letter starts if I'm preparing for finance department.
Yes. What do you say?
On last day, your lordship directed to obtain inspection to all the here 4 departments are there, lordship. As regards the present status of employment of the petitioner's lordship.
So IWT, they are receiving minimum of pay scale. And which department is there? PWD.
One more department is there, PWD lordship. My friend Rahul is appearing in it.
They are all receiving
Minimum of the pay.
minimum.
But their services have been regularized pursuant to the cabinet petition member. No,
Huh?
no, that is the.
In item number 4, मतलब I said to the petition member. Their services to regularize मतलब pursuant to the 2005. So that मतलब their salaries were not paid. Thereafter मतलब they approached the trouble court. These are directed the authorities मतलब to pay them the regular scale of pay. Against the order मतलब the state required review. If you was checked with Upendra मतलब there was no review. That is मतलब the earlier order passed by the criminal court मतलब that remained intact.
What was the earlier order?
Earlier order is that this rule to direct the to make the correction, necessary correction, and pay the regular scale of pay. Number 4.
See, all these petitioners were initially regularized by some order.
Yes.
What happened to that order? Is it recalled?
Lordship may kindly see my affidavit, lordship, filed by the finance department in WPC number 4431/2008.
Yes.
I'm just putting 2-3 documents. Lordship may kindly see page 14. Page 14. Lordship, this is the order passed by the Secretary to the Government of Assam Irrigation Department. This is dated 3rd of October 2005.
Page number?
Page number 14, Lord, Annexure 2.
40.
verify? That's one.
Hello.
Yes.
Lordship, this is an order passed by the government. Lordship will see bottom, Secretary to the Government of Assam Irrigation Department. It is dated 3rd of October 2005, Lord. Lordship, along with this order, your Lordship will get one list, Lordship. Page 16.
Page
16. 1-6. Same affidavit, Lord. Order is at page 14 and the annex list is at start from page 16.
Hmm.
Lordship, this is the list of the MR workers, Lordship, whose names were approved by the cabinet for regularization of their respective services. Lordship.
The petitioners' names are not there.
Not here. Lordship, subsequently, Lordship, the concerned executive engineer prepared a list of his own.
And where is that order which was by which you were regularized?
Lordship will see
The
page
petitioners were regularized.
annexer 20.
Lordship, may kindly look at have a look at page 15 first, madam, of the document my learned friend was referring to, madam.
No, show us the first order by which they were regularized, on which they are banking their claim on.
Item 4, my lord, page 41.
Double 341, where is that order?
3341, my lord. Lordship will
kindly
find,
see
my lord,
annex-
page annexure 19, my lord.
Page
Page
32.
page 19, annexure C, my lord.
Hmm. This is passed by the executive office engineer.
Lordship, in my affidavit, Lordship, page 32. Page 32, annexure and page 32, this is a letter by the executive engineer to the secretary to the Government of Assam Irrigation Department. 14/11/2005. Lordship, may kindly see the last paragraph of that. Bottom.
Hmm.
It is stated here that on scrutiny of approved list of MR laborers along with the list of MR laborers sent by the letter number quoted above, it is found that there are some printing errors in the approval list, and as such there has been corrected and appointment letters already been issued as per your valued instruction. In this connection, statement showing correct name list of workers staff and MR laborers with detail as per approved list is submitted herein below for favor of kind disclosure. Lordship, that list prepared by the executive engineer start from page 34.
Hmm.
One name your lot, list will find at page 35, serial number 33, Nazimuddin Lotford. Page 35.
$35 of
Same affidavit.
yes.
First, serial number 33, Lord. Nazimuddin Lotford. His petitioner number 2 in this petition, Lord. Lordship, I kindly see the remark column, Lordship. Column number 5.
What is the meaning of this?
Lordship, according to him, one name appeared twice in the approved list, Lordship. That is why he corrected the list of his own without taking any approval of the either of the authority or of the cabinet. Lord.
So this is the list which was approved by the cabinet.
Not by the cabinet. It is the list prepared by the executive engineer, and the petitioner's names were included in that list.
So the list was prepared by the cabinet, my lord. It was sent by the executive engineer make some corrections. This is the
No. You mentioned something about the list.
List, Lordship will find the first list at page 14, page 16.
This is the list sent by whom?
Approved by the cabinet.
Cabinet.
Lordship may kindly see serial number 33 there. In the
33.
list approved by the cabinet, serial number 33, this is Basiruddin Loscar. Nazimuddin is not there. Nazimuddin Loscar is not there in the list approved by the cabinet.
It is there at page 26, serial 26.
He is somebody else. Sir.
How do you know?
It's a different person.
Different person.
Is it a different person?
Petitioner number 2 here in court.
He is Nazimuddin.
Yes. I think, but perhaps this is a different person. It may be a different person. Lordship is right, in page in serial number 26 is Nazimuddin Loscar is there, but I think it's a different person. In fact, my lord, age 15, Lordship will find, my lord, after this list was prepared, my lord, the executive engineer was asked to, my lord, inform about any discrepancies, my lordship, page 15, my lord.
What action have you taken against the executive engineer?
Yes, Lordship may kindly see page 11. Page 11. Lordship, these orders start from page 9. This is Annexure 1, Lordship. This is the order passed by the authority, Lordship, convening 10 departments as regard the approval of the cabinet. That this many numbers person is going to be regularized and cabinet has given approval. Page 11, Lordship. Lordship may kindly see serial number 5 and 6. Serial number 5, page 11. The posts are personnel to respective workers, master roll workers, and will be abolished as soon as the incumbents relinquish the post in any manner. So posts were not created in general, Lordship. Post was created against an individual person. Against my name, one post was created. It was not against his name. Lord. That is one. 2. The post will not be filled up by persons other than those workers, master roll workers, for whom the post have been created. So that is the issue, Lord. If it is created for me, that post will be filled up by me only.
No, that is all
and not by
right.
any other person.
But you see, it is not your allegation that this order is forged. It is issued by an officer of the guard department.
Yes. Lordship may come to.
If he had no authority to appear, then there should have been a clarification by the department that he
Yes,
is
that
not
is
authorized.
already there, Lordship.
Huh?
That is there. Page 45.
45. Yes.
From Commissioner and Secretary to the Government of Assam Finance Department to Secretary to the Government of Assam Irrigation Department. Lordship, this order was issued after having a thorough inquiry by the concerned Deputy Commissioner, Lordship. Lordship, may kindly see the next page, page 46.
No, there is nothing to say that the order of the executive engineer is unauthorized or
Yes, that is there. Lord.
where?
That is why I am placing this
Page
order.
46.
Last paragraph. Lord. I am reading the conclusion. I am therefore to say that Governor of Assam is pleased to order for cancellation of the appointments of the above mentioned 6 MR workers accordingly, and also order for abolition of 2 personal grade 4 posts created twice for regularization of the service of Sarvasri Hussain, Ahmed Majumdar, and Basiruddin Loscar.
You are reading from which page?
Page 46.
46.
Last paragraph.
Last paragraph ends at serial number 9.
In my affidavit, it is page 46.
46 is a continuation of some
It
order.
is continuation of letter dated 17 April 2008.
17 April.
Annexure 4.
Annexure 4. Dated 17th April 2008.
Yes.
But I am reading the last paragraph of that paper.
Yes.
I am therefore to say that the Governor of Assam is pleased to order for cancellation of the appointment of the two above mentioned six MR workers accordingly, and also order for abolition of two personnel grade 4 posts created twice for regularization of the service of Sarvasri Hussain Ahmed Mojumdar and Basuruddin Loscar. The four personnel grade 4 posts created for regularization of the service of Sarvasri Anaruddin Barbuya, Nuruddin Barbuya, Mahbubur Borloskar, and Mokabbur Ali are already abolished consequent upon the date retirement. In terms of Finance Department letter dated 22/8/2005 mentioned above, necessary action may be pleased be taken for abolition of the post and also for cancellation of the appointment order issued by the executive engineer. That is their lordship. Next letter you have page 48, lordship. Page 48, lordship.
When was this letter issued?
This letter was issued on 17th of April 2008. Next letter is page 48, lordship, again by the Commissioner and Finance Department to Irrigation Department. I'm reading last but one paragraph, lordship.
Yes.
I am therefore to request you to initiate disciplinary action as per Assam Services Discipline and Appeal Rules 1964 against the concerned Executive Engineer Silchar Division Irrigation, who is responsible for regularizing the service of the above named six pastoral workers without authority. Next page, your lordship will find the cancellation order. 49.
Yes.
7 December 2009, in inviting a reference to the subject cited above, I am directed to say that the six numbers of personnel posts against which the Executive Engineer Silchar Division 1 Silchar had unauthorizedly regularized. The six numbers of MR workers have been abolished by this department office order number 7/12/2009, and the Executive Engineer's order for regularization of the incumbent against the post has also been cancelled by the same order. Further, it is informed that disciplinary proceeding against the executive engineer concerned and other officers and staff involved in the unauthorized regularization has already been initiated by this department. Lordship, now one thing your lordship will find, in none of the repetitions, lordship, that cancellation order is not affected.
Yes.
Remaining portion, one statement is there, lordship, in my affidavit, page number 6, lord.
Yes.
Case number 6, Lordship.
Yes.
First paragraph, Lordship. After termination, the Treasury Officer Silchar has, however, been advised to allow wages to the G6 MR workers, the petitioners in the petition number 4413/2008, if found otherwise eligible by memo number. So they continued to get the MR salary, Lordship. And after Upenda's judgment, Lordship, all of them has been given the benefit of paragraph 25, paragraph 22, and accordingly they are now getting a salary of around 20 to 20,000. Some of them already retired. Next paragraph, your Lordship will notice, Lordship. Subsequently, the Irrigation Department by letter number 7/12/2009 informed the Finance Department that 6 numbers of personnel posts against which the Executive Engineer Silchar Division 1 unauthorizedly has been abolished. Next paragraph, your Lordship. Lordship will skip that paragraph. Next paragraph. It is stated that proposal for regularization of service of these 6 petitioners has also been submitted by the Irrigation Department by their endorsement dated 26/12/2008 in their file number so-and-so, along with the proposal for regularization of services of other left-out workers, MR workers engaged by the department prior to 1/4/1993 and have been rendering uninterrupted service since their joining. On scrutiny, it was, however, found that in respect of one of the petitioners, for example, Mohammad Nizamuddin Loskar, alias Nazimuddin Loskar, has required supporting document has not been furnished, and hence the Irrigation Department was requested to furnish the same. It may be mentioned here that no decision regarding regularization of service of left out workers, MR, and similar other workers would be taken because of the restrictions on further regularization imposed by the Honorable Guwahati High Court by this order dated 17/5/2006, passed in WPC number 6222/2003 and 173 others. This is Jitendra Palita and others. Reported in 2006 2 CLP 645 and order dated 27/3/2012, passed by the Honorable Division Bench in Miss Case number 597/2012, filed in WPC number taken up 24/2007, filed by the state seeking leave to implement its policy of regularization. Lastly, the Honorable Division Bench of Guwahati High Court in its recent judgment dated 8/6/2017.
But
passed
it is
in
open
WA
to
number-
the state to adopt any policy, one-time regularization if you want.
Yes. In 2005, Lordship, we had one policy. In 2005, Lordship, those who were left out, for their regularization also, Lordship, proposals were received from various departments. But in the meantime, Lordship, Umadevi judgment came, Lordship, and Jitendra Goelta judgment came in 2010. Thereafter, Lordship, we filed one miss case in that Lordship will find mentioned in this affidavit, Lordship.
So notwithstanding that, even in Umar Devi, there is a proposal that in case they put in the 10 years of service, the government can formulate a scheme for regularization. Where is the bar?
So that's requirement of sanction post law. Three conditions. Lordship will kindly see that order passed by the division bench.
Which
fact,
division? Which order?
But Lordship has already seen that mentioned in my affidavit, Lordship. This is case number, miss case number 597/2012, Lordship. It was filed by the state of Assam in the case of Tarini Dekha, Lordship. It was taken up 24/2007. It's a very small judgment, Lord. The
No, it's
issue
not a
taken up-
judgment. You had sought for permission from the court. Court
Yes.
said that if you cannot regularize in terms of the law laid down, you cannot.
Yes.
This is not a finding on facts.
No, here, Lordship, court say if law doesn't permit, Lordship.
That's right.
How can I
So
pass a
if law
direction?
does not permit, why should you make an application? The question is whether law permits you to do it or not. Have you taken a call on that?
In subsequently, Lordship, by following Umadevi judgment, that one-time major, Lordship, in 2013, one notification was issued.
Then
Those who have fulfilled those 3 conditions, Lordship, as enumerated in paragraph 53 of the Umadevi judgment.
what are the conditions?
Lordship, one is holding a sanctioned vacant post.
It can't be their master role workers.
This is the condition, Lordship, scheduled by the Supreme Court. Lordship.
That is the You have to create posts if required. Supernumerary posts.
Even
Something
creation
which
of
is not there. You have extracted services of these petitioners as master roll workers.
2012 Lordship, we passed one notification. There we took two decisions, Lordship. No more creation of supernumerary posts. That is
Then don't create. That
and
is
no
your
more
it's a decision you have to take.
that decision is
You are extracting today, even today, as per the reports given, they're working as master roll. Why do you want them as master roll? Why can't you create regular posts? Why can't you go for regular appointment? Why do you want master roll? Why do you want to extract services out of the petitioners?
No, issue is whether their services can be regularized, that is subsequent. In this petition, Lordship, they are claiming for regular salary. And our stand is your service was not regularized.
That's
never
right.
regularized.
That's right. But whether they were on the same footing as those people whose names were there in the list and their names were dropped off the list for no fault on theirs is a decision required to be decided upon by the state. Once you take a decision, you have to now find out a way how to ameliorate their grievances.
But by going by the Upenda's judgment, Lordship, alternative. Either as an
Upenda's
alternative
Upenda's judgment is a claim of the petitioners therein, saying that we want regularization having rendered for so many services.
No.
This is not the issue here.
One
The
of
issue
the
is
issue,
that they were working. They were shown to be regularized by an office order. And they were given salaries. Suddenly their salaries have been stopped. But you are allowing them to continue as master roll. Then as a master roll worker, what right does a master roll worker have vis-a-vis the procedures laid down for which are applicable for a person regularly appointed? Why has the department permitted them to work as master roll? If there are no posts, you create posts.
Submission, Lordship, the issue, only issue before your Lordship, whether they can be paid regular salary or not. And
Of course not. But
No.
the question is,
that's
no,
satisfactory,
that will not. That is only a part of the issue. The
Regularization is
question
not
is,
to
if you have not
increase
been able to pay regular salary, why have you taken the benefit of the services by rendering extracting master roll
They are
workers?
claiming regular salary on the basis of an order passed by the concerned
Your
executive
employee.
Lordship.
The order was passed by an employee under the department.
Executive engineer.
Whatever.
Subsequently, that was found unauthorized and that was cancelled. So that satisfactory,
But whether their claim with regard to the other persons who were regularized in that list,
Lordship, that is not a subject matter in my humble submission. That is not a subject
can
matter
we
of
not
this
make it a
issue.
subject matter?
The regularization is not a subject matter.
We can
of
make
this
it a subject matter. We can make it a subject matter.
issue.
Why should you not examine this issue? See, their claim is, which we do not know, for all the good reasons, the executive engineer must have thought two persons, why the same name is necessary, strike it off, give it to somebody who does not have. Maybe he was not authorized to do it. Proper authority, proper procedure ought to have been adopted. But fact remains that their names were not included there.
Yeah.
Had their names been included, they would have been regularized. Now, does it preempt the government from taking some step in respect of their considerations for
My
regularization?
Lordship, subsequent to Uma Devi, as a one-time measure, we issued the notification of 2013 for considering all the letter master roll workers. Those who fulfill those three conditions, their services can be considered for
But
regular.
master roll workers, do they work against sanction post?
Some persons were, even after that notification also, Lordship, some persons were regular. That is one-time measure, Lord.
Yes.
Well,
Amicus,
First of all, my lord, as the Lordship has pointed out, they have not pointed out any difference between these persons who have been left out and who those were regularized. Now, the
no.
list which is
This is not even the issue here.
My lord.
You'll have to find out whether you are qualified, your names were not sent. These are not the issues raised here. The issue is very simple, that you are regularized. Subsequently, your salary has been stopped.
Yes.
Stand of the government is that this order was passed without any authority.
That's true.
है ना?
Subsequently, two of the petitioners here, they filed two petitions again, which are also part of the citizen. They have asked for prayed for removal of the anomalies in the regulation process. They have prayed for that. There is no affidavit filed saying that these persons stand on different footing, that therefore they cannot be regularized. The finance department prepared a list, the cabinet prepared a list. That list, in the list itself, the executive engineer was asked to point out anomalies, if any. That will Lordship will find at page 15. 15 is very clear, that the executive engineer, he has to point out the anomalies. Lordship will see page 15 of the affidavit filed with the which my learned friend was referring to. Of the affidavit, Lordship will find the serial number 3.
Page 15.
Page 15, 1-5. He is also in Lordship will find executive engineer so and so, Then, my lord,
We are unable to locate page 15 of the affidavit
filed by the respondent number, my lord. That's
Finance Department.
Respondent 3, my lord. Commission and Secretary Finance. Yes. By Dipali Das, my lord. Srimati Dipali Das.
Yes. Then
My lord, page 15, my lord.
internal page 15.
15, my lord. Page 15. Annexure 2, 14 it starts, my lord.
Yes, page 15.
Page 15, my lord. The executive engineer, so-and-so division, for information and necessary action, is requested to issue orders of appointment for the purpose of regulation of services for work charge master workers as per approved list, after proper examination of the bilateral personnel so-and-so. He is also instructed to inform if any discrepancy is noticed in the approved list immediately to the chief engineer irrigation. My lord, thereafter, what this executive engineer did, my lord, he, my lord, deleted some of the names, my lord, which were either appearing, my lord, in duplicate, my lord, in my lord, or, my lord, some people were not in the list, my lord, were already retired, my lord. But you will find, my lord, page 35 onwards, he has made some entries, my lord, here. Remarks has been given, my lord. First one, my learned friend has referred, my lord, that one double entry in the name of Basit Uddin Laskar has been found in the approved list under serial number 33.
So what is your submission as an amicus?
My submission is, my lord, since this list was already prepared, my lord, and, my lord, these people are not, my lord, found to be otherwise different from those who have been regularized.
What is the material to arrive at that conclusion?
My lord, there is no denial of the fact, my lord, that these people are, first of all, they have not denied, my lord, they are not working, my lord. It's admitted position they are working as master worker. It is not, also, my lord, admitted position that they are working prior to 1493, my lord. That is also not on dispute. So on that pedestal, my lord, they stand on similar footing, my lord. Once they stand on a similar footing, my lord, they couldn't have been treated differently, my lord. Therefore, my lord, even if this order of the executive engineer was without authority.
No, but there has to be a proper decision at the government level regularizing.
That they have to take, my lord. But then there are, my lord, other, since once they had regularized these people, my lord, for some reason, right or wrong, they've been left out. Now, this is the department government which has to say, my lord, why they were left out.
They have given the reasons.
No, my lord, totally
that's a wrong order.
No, they're totally silent. Why they were left out initially? They are only, my lord, giving reason is, my lord, that the executive engineer, my lord,
Why they were left out is not even an issue pleaded here.
My lord, their case was that, my lord, we should be given our salaries, my lord, since the order was given. A subsequent 2 persons came, my lord, saying that whatever anomalies are there, my lord, they should be regularized. My lord. That's the, my lord, one of the petition number 2 and 6, my lord. They filed 2 separate writ petitions, one. That is WPC number 43273.
We can direct the government to give reasoned orders on this. That is direction we can give.
Of course, that's the decision they have to take, my lord.
But in so far as the present issue is concerned, it appears that they were wrongly given the salary.
Apparently, my lord, because wrongly, my lord, say, my lord, then since the executive
Wrongly unauthorized.
Since the
unauthorized.
Executive engineer's proposal.
Have you started recovery also?
My friend is appearing as an amicus curiae lot. It is not take party lot.
He's not.
He should not.
He's not. We are not permitting him to take parties. We are just asking him.
On the legal issues, not.
That's what I'm saying. My submission is that since there is no difference as such between these 2 sets of people, my lord, therefore, my lord, there ought to have been, my lord, considered the case, my lord. That's what I'm saying, my lord. I'm not, my lord. And, my lord, so far the other petitions are concerned, the facts are slightly different, my lord.
Other petition?
My lord, it's only, my lord, with regard irrigation department, my lord. My lord, petition number WPC number 141202 of 13, my lord. Now, my lord, he was my lord engaged as a master worker, my lord. Now he is claiming, my lord, regularization in terms of the cabinet decision of 22/7/2005, in which his name did not appear. So this is a case, my lord, where the person concerned is claiming regularization on the basis of the office memorandum, my lord, or cabinet decision, which was taken in 2005, where he was left out.
No, you tell us, you submit as to what orders can be passed by the court
My lord,
effectively.
Of course, my lord, this has to be, my lord, they have ultimate decision they have to take, my lord. So, my lordship will direct the consideration.
You come back again on Thursday.
My lord.
Go through it properly.
Thursday, my lord, I'll be out of state, my lord. I'll be difficult. Can you be on Tuesday next, my lord?
All right, Tuesday next.
Tuesday. Any partner?
No partner. What partner? Tuesday next. Come back with your arguments as an amicus. If there is anything to be submitted, that's all.
My basic case would be, my lord, that since they were, my lord, on a similar footing, my lord, the endeavor should be made, my lord, to
That is on the factual aspect.
Yes.
You tell us on the
legal
aspect,
side.
examining the law. You examine what orders were passed
Yeah.
in Jitendra Kolita, subsequent matters, then read with the IA what other orders were passed. You make a synopsis of this,
Yes.
place it before the court. Yes,
Jitendra Kolita, my lord, was with regard to 2005. That's got nothing to do with here.
very well. You
Because 2005-7 regulation was not at all touched, my lord. I'll prove that. That was not even touched.
yes, on 14th, Mr. Mahmood, for further hearing on 14th. Mr. Huh? Why?
Let it 14, let it 14.
2013 matter, we should have finished it this week only.
2006 matter.
6 matter, yes. 8 matter. 6 and 8. Let it be on 14, let us see. Yes. Record the names of the council. Yes, we are keeping it. You also keep one copy handy on the next date in case it is not available.
Obliged, sir.
Please read your lordship. My lord, in this case, petitioner promotion to the post of warrant officer and MSCP benefit is not given, my lord. He has filed representation and department has replied to that saying that, my lord, my SCR is not, my lord, up to the mark. Kindly say,
Your Honor,
at this stage, I am paying for notice only, my lord.
those don't like my lord.
Who?
I think
Only notice, my lord.
We are only issuing notice. That
My lord.
you convey to him. Third, learned counsel for the parties. This petition is filed by the petitioner. Praying for a direction from this court to consider the case of the petitioner for promotion to the rank of warrant officer, GT, with effect from 1st of April 2021. From the date on which the junior was promoted. With all consequential service benefits. And grant the service and grant the benefits of the third MSCP on completion of 30 years of qualifying service. By expunging any uncommunicated adverse entry that may have been made to the ACR. Stop. The petitioner claim for MSCP benefits were not released on the ground that the ACR were not found to be of the where is that communication?
Page 18, madam, NSR 3. Page 19, it is in Hindi, madam.
That his ACRs for the year 2019 and 20 did not confirm the standards of MACP Roman 3 and promotion. Being agreed, the present writ petition has been filed. And I issue notice returnable for which Mr. A.B. Dotto, A.B. They appears for on behalf of Mr. Dotto. You do not appear for the respondent.
No, my lord, Mr. Dotto
Appears on behalf of Mr. A.K. Dotto. Stop. Since the respondents are represented by standing counsel, notices are waived. However, extra copies will be furnished to the respondents within a period of 1 week from today. At least after 4 weeks. Respondents will file a counter in the meantime. Yes.
This is a case for promotion to the post of junior assistant manager from the post of grade 4 employee. Petitioner was initially appointed in 1992 and subsequently his case was earlier recommended for such promotion value that was rejected on the ground that he was not qualified. Because requisite qualification is not.
We'll have it for admission hearing.
Yes, ma'am.
It's for admission hearing.
My lord, if they don't want to file a reply, that's recorded matter.
It is filed.
Filed already.
Reply is filed.
Reply already.
You give him a copy.
Filed. Reply filed.
Data that 7 December. Admission hearing.
Lordship, item, Lordship, item number 1615, Lordship. But I need for amendment of the IA Lordship on 890. There is a mistake, Lordship.
You want to file an amendment?
Lordship. In IA, page number 7, Lordship, at procedural Lordship. IA number 1615, Lordship.
Yes.
File is page number 7, Lordship. Schedule Lordship. Name Lordship. I just try to be mistake, Lordship.
Yes, any objection?
No.
Heard learned counsel for the parties. This IA has been filed by the petitioner seeking amendment of the name of the applicant. Stop. In the IA number 890. This is for substitution.
Yes.
890 is for substitution. The name of the applicant was wrongly entered as within quote ceremony AWAGATA. Home Chaudhary. HOLME. Home Chaudhary. Quotes closed. Stop. Learned counsel for the applicant presently submits that he may be permitted to correct. He may be permitted to delete the earlier name entered and substitute it by the correct name, namely within quotes Srimati Swagata, Swagata, HOLME, Home Chaudhary, quotes closed. Stop. The further prayer is that in page 5, para 3, subpara 1, the name within quotes Srimati Agata Home Chaudhary, quotes closed, be allowed to be substituted by the word Srimati Swagata Home Chaudhary in the IA 890. Para MSS Sharma, Learned Counsel for the department. Health Department does not
1,
object.
2, and 4.
Does not appearing for opposite parties 1, 2, and 4 does not oppose to the prayers made. Mr. Any government counsel? Huh? Mr. Rad Horland counsel, government advocate appearance for the other respondent. No objections have been raised. Accordingly, the I is allowed. The applicant is permitted to change the name of the applicant in IA 890 of 2023 from Agata Home Chaudhary to Swagata Home Chaudhary. Stop. Similar corrections are also permitted to be made in page number 5, para 3, subpara 1 of the IA number 890. Stop. The petitioner will, however, file and a copy of this order be placed in IA number 890. Stop. IA 1615 stands disposed of. Why don't you withdraw and file another one? In IA 890, you write in view of the order passed in IA 1615 of 2023, passed today. The name of the applicant, Srimati Agata Home Chaudhary, is permitted to be, is deleted, and in its place, Sri Swagata Home Chaudhary should be reflected as the applicant, as the wife of the late petitioner. Stop. Similar corrections are also made in para 5. Is it para 5?
No, sir.
Page 5. Page 5.
Page 5.
Para 3, subpara 1. IAP registry to make necessary endorsements and list the matter next week. IA 890, huh? IA 1615 stands disposed of.
Okay.
Yes.
Yes, I'm praying when this time, Lord, due to my personal instruction has been received, Lord, I have shifted my chamber, so do not prepare.
Next week, at the request of Mr. Sharma, P. Sharma, who appears for the AFPC, matter stands adjourned to next week. Mr.
R.S. Ronghang, on behalf of JSP.
R.H.
Ronghang.
Ronghang
Appearing on behalf of Mr. JSP.
appears on behalf of Mr. J. Chutia. List next week.
May I please, Your Lord? In this matter, Your Lord, I pray for adjournment, Your Lord.
51 at the request of Mr.
May I understand I am not in record, my Lord, on behalf of A.K. Purukar.
Makes a submission on behalf of Mr. Purukashta. The matter stands adjourned for the day. MSC Bora appears for the respondent.
May it please the
Yes.
52 and 53 are connected matters. Nurses are before your lordships. And
Huh?
there's an interim protection also available to us. I believe during the Puja vacation, the notices were sent. We have taken steps on time. Perhaps the service is not completed. One is representing. May I pray this be listed on the may I pray this be matters be lifted towards the last week of December. In the meantime, they may file the response of that.
Who's you're appearing? 5 in 6085 WPC.
Lordship.
Both the cases.
Now, our
as,
party is done. They have to file the response to it.
as per office note dated 19/10/2023, notices issued where sir have been steps have been taken as in terms of the order dated 1911. In terms of the orders passed by this court issuing notice. Stop. Mr. What is your name? A. Decca appears for respondent 5. However, none has entered appearance on behalf of respondent 6. Matter be listed again after 4 weeks.
Before the vacation.
After 2 weeks.
I mean, the stand of the other respondent whose service is not complete is more important. State, because they have to take a call. The interim protection is granted on that.
You can take Dusty if you want. No.
No, we have it has just been dispatched, but we can wait for the normal
It will
time.
be after 3 weeks.
After 3
Let
weeks.
us-
After 3 weeks.
Matter be listed after 3 weeks. The respondents may file their counter affidavits in the meantime.
Interim protection to continue.
Interim protection granted by this court by order dated
Ours is 11/10.
11/10/2023. Be extended until the next date.
Could it be until further orders? Because these are services of nurses with us. Let them be under protection. Otherwise, the stand is only required.
Let it be till the next week first, then we'll see.
Gotcha. Until next day.
Give a date after.
December 4th.
December,
Wait
till
for-
4th of December.
Right.
In the second matter, is there also an interim?
Yeah.
Same date,
Same subject.
same date, same subject matter,
Interim order dated is 13/10.
13/10.
13/10.
First matter 11/10, second matter 13/10. Interim order extended till 4th of December.
Well, may I pray both these matters be tagged together? If not, tagged
Yes,
together?
both the matters we listed together. 52 and 53.
Lordship, here is this, on the last day, Lordship, I was supposed to sign an affidavit, Lordship, to bring on record that we have intimated about the writ petition to the private respondent, by the respondent number 4, Lordship. That affidavit has gone for getting, Lordship. We'll be filing it within 2 days, Lordship. Otherwise, Lordship, we have already informed them.
The affidavit permitted to be filed by the respondents for effecting service on the private respondents through the respondent number 4 has not yet been filed. Mr. D. Upamanyu, Learned Standing Council Health, prays for further time. Stop. Mr.
Yes.
S.
Alam.
Alom, Learned Council for the petitioner does not object. List again after 2 weeks.
Only. But that may be given. Matter is mainly
2 weeks.
Can you take some admission, my lord?
He's not filed some affidavit. Let it be filed and matter be listed after 2 weeks.
Date may be picked otherwise, my lord. Always
Give a date after.
any day before 26. Oh, deeply okay.
Why 22nd? It's for admission.
For admission.
So we'll see.